Yes.
One second appeal of 2000 murder. The matter appeared before lordship on 6th December. But as nobody appeared on behalf of the substituted respondents, the matter was directed to go after me. I have already entered appearance, but I could not appear on that day. There was a direction for service. I have already served notice upon the advocate for the appeal.
After mentioning it was listed, but no one appears, so what can I do?
No, my lord.
There are several matters.
In terms of the direction of the earlier direction of the coordinate which the matter appeared.
So you must appear at the date of
Yes,
fixing.
I was engaged in code number 4.
Someone has to be there. Otherwise, there are lot of person to be accommodated.
Not
Again, if you not appear, it will go out of the list.
I shall appear.
Okay.
May
You are appearing on behalf of the
All the
appellant.
respondents, including the substitute respondent.
Respondents.
I have served this.
10th of January.
Madam, may I permit to mention one restoration application, madam?
One stay application.
Restoration application.
Restoration application in connection with second appeal.
No, my lord, it is a group 8 matter.
Group 8 matters.
May I have a lordship's kind leave to mention, my lord, and second appeal, my lord, pending from 1993. My lord, the matter appeared before the Honorable Justice Champada Court on, and my lord directed the matter to appear in the month of September. Since then, my lord mentioning that matter is not in the list. My lord kindly praying for the inclusion in the list, my lord.
You are appearing on behalf of whom?
Appellant, my lord. Thank you.
Appellant. Have you served notice
Yes,
upon the
my lord, I have
respondent?
checked on service.
Okay.
Okay.
May I permit to mention for
10th of January, it will be listed 10th of January.
Second appeal. Appellant.
My lord, may I permit to mention for non-prosecution on instruction from the appellant. We are for the appellant.
Second appeal.
Second appeal. For non-prosecution.
My lord,
3rd of January.
Third of January.
March of like-
3rd of January.
Grateful.
Grateful, my lord.
This matter will come as listed.
Under the heading application.
Application. 3rd of January.
This matter will come as listed.
Listed? Listed group 8 matters. Okay.
may I be permitted to mention one urgent matter, lordship, that
What urgency?
urgency is that, lordship, we are challenging one vacancy, lordship, that I have applied for the vacancy of a ration dealer shop, lordship, and then after it was allotted to someone else, lordship. He is the primary respondent in my matter. Now, lordship, this subsequently when the matter was filed, lordship, this bench was vacant, so this matter was mentioned before the Honorable Justice Rai Chattopadhyay, and this matter was taken up for hearing, and subsequently lordship has appeared. So this matter was running before the Honorable Justice Rai Chattopadhyay. This matter was taken on Monday, and lordship, I submitted before her lordship that the matter be released, and subsequently it has been released, lordship. Let be included before your lordship list. And the other side was present on that day, lordship. I will also intimate to them that, lordship, when it will be come.
23rd of December.
23rd of December, lordship. I am just handing over the number of the case, lordship, and I will notify the other side also, lordship. Grateful to your lordship.
Give me the proper slip. What is the slip?
Lordship, allow me to few minutes.
This is not the way to give you slip.
Lordship, but
Give the proper slip.
Hearing of second appeal, my lord. I am for
Second
the
appeal.
Yes, lord.
You are
Appellant, my lord.
for the appellant.
Pending
How many second appeals?
one second.
One second appeal. Have you served notice?
Yes, sir.
What is the status of the appeal? Ready?
Ready. My lord, paper book complete everything.
Whether any application is
No,
pending?
no application.
Everything is ready. Very well. 10th of January.
My lord, may I be permitted to be mentioned, my lord? I am praying for inclusion, and this matter relates to second appeal, my lord.
Second appeal.
I
For
have
the
served-
year
2007, my lord.
2007.
Yes, my lord.
You are appearing on behalf of whom?
Appellant.
Appellant. Have you served notice of
Yes,
the
my lord. I
respondent?
have served.
You have served notice
Yes, my lord.
before mentioning
Before mentioning, my lord, I served by speed post, my lord.
directly to the respondent or the learned counsel.
Uh, to the parties, my lord.
To the directly to the
Parties,
parties. So
yes.
where is the postal receipts and otherwise documents?
My lord, I served, item is delivered, my lord. When the matter is taken up, I will serve the affidavit of service, my lord.
You know, the date has to be fixed. Otherwise, how can you assess the affidavit of service? How you serve upon the respondent regarding mentioning this matter?
Yes, my lord.
Today's mentioning matter.
Yes, my lord.
You have served them that you will mention it today.
Yes, my lord.
This is your service.
My lord, I served mentioning notice, my lord.
Sub mentioning notice.
Yes.
Very well. Take it.
Lord, may I be permitted to
10th of January.
Grateful, my lord.
permitted to mention one application, my lord.
My lord, may I have
For the appellant or respondent, you write it down. Yes.
my lord, may I have your kind leave to mention two applications, my lord?
Application in connection with what?
Second appeal, my lord.
What applications? What are the applications?
My lord, kindly,
You do not know.
I'm not aware, my lord.
Then you come and move.
My lord,
Yeah.
may I be
Yes.
permitted to mention an application, my lord, in connection with second appeal with 2013, my lord. The second appeal was filed in 2013. This is an application in 13.
2013.
This application is for setting aside of abatement, my lord.
Setting aside abatement.
When I will assert the other side.
Have you served?
Yes, yes. I had the application attached to the service.
Your
10th
lordship,
of January under the heading application.
your lordship, may I permit to mention a matter? Extension of interim order, Group 8 matter, lordship. Interim order has been expired last week, and kindly keep it on under heading to be mentioned.
To be mentioned 23rd of December.
My lord, may I have your kind leave to mention one matter through on. I am sorry, my lord, I am mentioning through online. My lord, the matter is very simple. It is regarding the notification which you have passed so many judgments, same judgment. It will take only 5 minutes, my lord. It is running in the list since last 2 weeks and not coming within a one for one. Today is also in 22, my lord.
Item
Kindly
number?
22, my lord. My lord, kindly fixed it on 13, 23 or 24. I will be in Maharashtra National Law University in last week, my lord. Next week. So I could not attend in next week.
Today
20
it can be taken up. Today itself it can be taken up. You just wait.
Okay, okay, sir. Okay, my lord. Obliged, my lord. Obliged, my lord.
Okay, call the list.
Yes, yes. বলে দিচ্ছি স্যার কেউ নেই এই জাজমেন্টটা দেখাবো কি করে? কেউ নেই 2004-2 SCC 447 7 10 একটাই Milord, on the last occasion, Milord, I had concluded my submissions.
Yes.
But if your lordship recollects, Milord, I had relied upon a full bench judgment of our High Court, Milord, where, Milord, this honorable court had held that even if the principles of natural justice is not there, in the statute it is deemed to have been incorporated.
Yes.
But only one judgment, Milord, I had missed, which is reported in 2004 volume 2 Supreme Court cases on the same line. Just to give one Supreme Court judgment, 2004 volume 2 Supreme Court cases 447. Paragraph 10. But I have not handed up the judgment to your lordship's officer. But unfortunately, my lord, my juniors have not come. Kindly, my lord, take the trouble of looking at.
Give it to me.
Very unfortunate.
Yes, yes, well.
Standing, no junior.
আরে তুই থেকে লাভ কি? তুই তো মামলাই নেই। But kindly have a look to the underlined portion, Milord. But I'll hand up, Milord, a copy after some time. What will tell you? Height. The principal. Height is the principal, the Supreme Court judgment. দেখি দিচ্ছি কপি কোথায় জাজমেন্টের সব সবাই ব্যস্ত তোমরা, এতগুলো জুনিয়র কেউ নেই। Sometimes I feel that we have got wrong training to come to court by 10:30.
Yes.
This is the wrong training that has been imparted to us by our seniors, because our juniors don't follow us.
We both join same chamber. And at least 10-20.
No, this is the custom of this High Court,
Yes.
that all the advocates come must
Particularly
9:30. Within 9:30 they must appear.
We
The
are
junior
not.
must appear at least 9:30.
Yes.
Seniors usually come
Yes,
10,
yes.
10.
On the basis of the court case.
Yes.
And you cannot leave court before 4:30, even if you don't work,
Yes.
have any work throughout the day.
Okay.
Never.
Okay.
I have never left court
I've never-
before 4:30. But I'll hand up this judgment to your lordship. এই যেটা underline করা আছে।
Just I'm going through the.
Yes.
না না, একটা নতুন জাজমেন্ট আর কখন আসবে? মামলা হয়ে যাওয়ার পরে? সিঁড়ির কাছে আছে কি বাড়ির সিঁড়িতে আছে, জেনে লাভটা কি? অদ্ভুত করে।
May I pay one indulgence, my lord? I shall conclude my submission. For judgment is concerned, if any judgment to distinguish another day 5 minutes or 2 minutes. Because I have not trust, I'm not habituated to this also.
Then Mr. Sara, you have to come on 23. Prior to that, I
All
don't
right,
have the time.
all right.
You understand?
I shall give answer.
অন্য একদিন করে দাও, অন্য একদিন করে দাও। Yes. ছুটির আগে আচ্ছা, ছুটির আগে করে দাও। But otherwise, not I have finished. I'm grateful. But I'll hand up the judgment in course of the day. Kindly.
Very nice.
Talk again. But may I take your lordship's leave? তোমাকে এটা চাই? তোমাকে
আমি
সফট কপি আমি দিয়ে দিতে পারি।
হার্ড কপি নিয়ে আসছি। My lord, I need to file a supplementary affidavit. I have already served the copy. Just
Yes.
one document. You can record an order that filing supplementary. I have already served to the Advocate General, also to the state. Your lordship will not go through the same just now. I shall rely upon letter. My lord, initially, Learned Advocate General submitted with your lordship that point of maintainability so far the filing of petition by the association is maintainable or not. Your lordship observed that merit and preliminary objection shall be heard together. Accordingly, I have argued the case on merit, and so far the preliminary objection regarding filing of petition by association, I could not give answer because they have taken the authority. Mr. Advocate General has submitted at only 2-3 points. The first point, just I am asserting, association cannot move a petition and also cannot challenge the high of the NAC. It was his first argument. They are not the dealers. Petition number 2 is the secretary. Association is not person active.
Yes.
Association is not person active. It was his first argument. Then second argument was no cause of action. Mere passing of a legislature does not give any cause of action automatically.
Yes. There is a presumption of validity of a legislature. This is the second point.
But the first point is concerned, it's fallen from your lordship. So why the association, whether association can file a writ petition or not, relying on my the Bhumijibi judgment, your lordship, it has been fallen from your lordship. The third point argued, if so far the interim order is concerned, unless act is declared ultra vires, no scope to pass any interim order.
Yes.
And only ex officio unconstitutional case, balance of convenience is there, interim order can be passed by the court. Next argument advanced on behalf of the Learned Advocate General. He has gone through the pair A and E, read out, no relief can be granted at this juncture, no civil and evil consequences suffered by the members. That was his third leg of order. No constitutional violation, constitutional validity has not been challenged, natural justice concept has been changed, Previously, violation of principle of natural justice was contrary to law. Now, entire scheme has been changed. That was also argument. How petitioner has been prejudiced by not providing show cause notice, and then my lord, judgment has been relied on. That was the judgment. I shall give answer one by one. The first question is concerned. If you also kindly take up my petition, the cost item. Who are the petitioners? There are two writ petitioners. The first page of the writ petition, All Bengal Fair Price Shop Dealers Welfare Association and General Secretary, All Bengal Fair Price Shop Dealers Welfare Association.
Yes.
They are the petitioners. Now, you will also kindly come to the first paragraph of my writ petition. That your petition number 1 is a registered, recognized. Why I am saying recognized? Time and again, the secretary of the association is being called for by the principal secretary to discuss the matter about betterment of the public distribution system. I shall show the letters I have also shown. So we are recognized, not only registered, recognized by the state government food and supplies department of fair price shop owners of all over West Bengal, and used to look after the right, interest and benefits of the members who all have been running their fair price shop business all over West Bengal on the strength of their respective licenses granted by the licensing authority. So to look after the benefit of the members, this association has been formed. Your petition number 2 is the general secretary of the petition number 1 and is a fair price shop owner. He himself is a fair price shop owner also. Submission has been made on behalf of the state that none of the fair price shop owner is coming before lordship.
Yes.
But that is not the truth. Then your lordship kindly take the submission. So my case is that
Yes.
almost 80% of fair price shop dealers in all over West Bengal are our member. That is admitted position. This is the only strong union. Number of cases they have filed previously, that has been maintained. Thousands of dealers from various corners of the West Bengal coming before this court to challenge an illegal notification or order framed by the state government inconsistent to the central control order and for violation of fundamental right protected under Article 14, 91G and 21 of the Constitution of India. I can say before your lordship, the submission which has been advanced on behalf of the state, that an individual can come. My respectful submission before your lordship, that an individual cannot come. When he can come, if his license is terminated, a fine has been imposed, he can come and challenge. So far the cause of action he affected. He cannot challenge the entire control order, being an individual. And he can also come only after if any provision of control order affects his right.
That means particular cause of action which was arising out of a particular provisions of the statute. But the
moment
association can challenge the entire
that, yes, they cannot. And then the same can be challenged only by the registered association on behalf of all the members. It has been fallen from your lordship so far the Bhumijivi case is concerned. The concept of Bhumijivi case was numbers of people residing in a remote portion of the state having no financial capability to come before this honorable court, formed the association and moved their case. That is the concept of Bhumijivi case. Your lordship knows. So that has been allowed. I shall show to your lordship. The one reference I am giving before your lordship, there are, your lordship knows, numbers of association of cooperative society, flat owners association. If my lord kindly take note of that, there are breakdown of transformer. giving electric connection to the consumers.
Yes.
That is the members who will raise the complaint. Not by an individual, by the association, because it's the cause of all the members. This is a cause, I shall show to your lordship from the control order, new control order. It affects members, all the members' right. At any time, they may be punished or something else. The next course of action submission was association cannot challenge subordinate legislation.
Yes.
But subordinate legislation has no special protection. It's not a special statute. Every law is equal. I shall rely upon a judgment which says subordinate legislation has been interfered in a writ petition. I shall show to your lordship. So it is not protected by any other means. All laws are same, whether it is subordinate or main law, central law. There is no such differences. If there is no constitutional safeguard or it is inconsistent with the mother law, that is the central law,
Yes.
Supreme Court says it can be challenged by way of filing a writ petition. I shall rely upon the judgment. The third leg of argument was on behalf of the state, my lord, that there is no inconsistency. So far, the state controller is concerned and the central controller is concerned. I have shown to your lordship only at least 30 inconsistencies. Just I'm giving them reference, I shall not open the brief. There is a specific provision in the central control order. Within a particular time, you have to hand over the ration card to a consumer if they apply it for. In the state control order, there are no such provision. I have also submitted with your lordship how we are being prejudiced. In a month, 10 to 12 ration cards may be dealing from me on the ground of death or transfer. In a 1 month, 10 or 20 application may be made for new ration cards. If they kept it pending for years together, my consumers will be decreased.
Yes.
There is a provision in the central control order. Reasonable number of ration cards shall be tagged with a dealer so that dealership business can make economically viable. In the state control order, there is no such provision, which affects my right, because if today subdivisional controller of the respective subdivisions declare a vacancy of a new dealership by carteling 2,000 cards from my 4,000 cards, I am not protected by this control order. I have only 4,000 cards. As per desire of the subdivisional controller, he may declare a vacancy by carteling 2,000 cards, keeping another dealer with 12,000 cards. I have no statutory remedy. After whims of the licensing authority, at any time, cards can be delinked at the whims of the licensing authority. There is a provision in the state control order, which is also inconsistent of the central control order, that a person, even in case of compassionate appointment,
Yes.
after the age of 45 years, cannot apply for. I can say, my lord, this is not only unreasonable, unjust. This is impractical. Why I am saying so? My husband died at the age of 50. Wife applied for whose age is 44 years, 11 months. He got the license. She got the license. She can continue up to 90 years. There is no above age limit. Only for 1 month I cannot apply. It is not the case of the state that old man cannot run the dealership business. If I get the license at the age of 44 years, 11 months, I can continue up to 90 years also. I have very few cases of this type. I can show at least 50 numbers of dealers whose age is more than 80 years. There is no above age bar. This is not only unreasonable, unfair, unjust, this is impractical condition.
Yes.
At the age of 45 years, I will be no means of my life if my husband died. If my husband medically unfit, treatment is going on, I want to bring my wife in my business. His age is 45 on one day, I cannot apply for. I have to surrender my license. There is also a provision incorporated in the sub-control order that you can apply for resignation, but it is our whims when we shall accept it. I am suffering chronic diseases. I cannot go to my shop room. I have to continue unless you decide that your resignation is accepted. This is unreasonable, unfair, unjust. There is a provision in the central control order in definition part.
Yes.
That the ration articles shall be delivered from the fair price shop. In the state control order, this is the first time, by way of amendment, it was sought to be incorporated in 2013, that is pending before the Supreme Court. Issue is pending, and one division bench also held that there is an injunction order to continue, but no stay order. Accordingly, in another matter, stay has been granted by the division bench. So far, the duration scheme is concerned.
Yes.
But that has gone today. I am being forced to deliver ration articles to the doorstep of the consumers, which has been restricted by the central control order. You cannot take a single quota of ration article outside of your shop room. But the state control order forcing me, you have to deliver it outside your shop room.
So previously it was there, dual ration scheme is there.
2013 control order, that was not there.
Not there.
By way of an amendment, this has been incorporated.
That is dual ration scheme.
Duration scheme.
Now
That
what
has been
happened?
challenged.
Yes.
Division bench quashed and set aside the duration scheme. State preferred an appeal. SLP has been filed. An order has been passed. You proceed on the basis of the duration, but the judgment has not been stayed.
Okay. Okay. So the SLP is pending.
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 In the mean, during pendency of the same, another matter went up to the same division bench. And the division bench also granted stay. So far, this point is concerned. I shall show to your lordship.
Okay.
But today, my lord, this point are irrelevant because I have to challenge the new one.
New, what is happened in the new? In
So
the
far,
new control order?
they have already incorporated duration scheme.
They have
In the scheme, in the state scheme also.
Okay. In the
So far,
state,
the
according to
control
the
order-
state scheme.
Yes.
But in the central control order, there are no
There
such
is
scheme.
no, rather contrary, why I am submitting before
Okay.
lordship.
Okay. Okay.
It says I have to deliver the ration articles from my ration shop.
Okay.
Meaning thereby, I cannot take away any ration articles outside my shop room. Totally contradictory, inconsistent instruction upon me by way of this control order. You have to deliver ration articles to the doorstep of the consumers. But these are the inconsistencies. There are numbers of inconsistencies. During course of my argument, I shall show to your lordship, so far the penal action is concerned and others
Yes, yes.
concerned. But submission on behalf of the state that there is no inconsistency, this is not correct. The reasonable opportunity for it. So far the penal action is concerned. So that the fourth leg of submission of learned advocate general before this court was mere passing of any legislation automatically does not give any cause of action.
Yes.
I have already filed a supplementary affidavit and I have served the copy. So kindly allow me to just show 2-3 documents. Whether it has been given effect or not. According to the state pilot, just before taking, I can come only when the cause of action will be arising. That is after termination of my license. After preparing appeal, first appeal, second appeal, then I shall come before this honorable court and writ petition will be filed. There is no scope for interim order. So I have no preemptory protection. Your Lordship, kindly take up, I shall show to your Lordship that whether this has been given effect or not. Kindly turn to page 5. Well, this is a certificate issued by my client, petition number 1, to one of the members, Kamala Devi Agarwal and Shyam Sundar Agarwal, issued on 17 January 2013. This is a partnership firm running APS dealer business from Jorashako sub-area under Kolkata North Subdivision Control as a bona fide member of our association. Have you looked at it? But subsequently, this partnership firm has been converted to proprietorship firm, and one of the partners granted the license. Kindly turn the page. And accordingly, he also became the member of the association, Shyam Sundar Agarwal. Have you Lordship got from next page? Now, your Lordship, kindly come. The receipts. Subscription given by 2016 by the partnership firm. It continues. I have annexed all the 2017-18. Your Lordship, kindly straightaway come to page 30. After becoming it proprietorship, he is also continuing as a member, as individual dealer. That will appear from page 30. Now, your Lordship, kindly come to page 40. But a show-cause proceedings has been initiated against the very gentleman. Kindly turn to page 14. On 26th of September 2024, kindly see the charges. A complaint received from a person, namely so-and-so, for a service at your SPS so-and-so has stated that you have been found violate the provisions of West Bengal targeted public distribution system regarding the following points. Beneficiary who, after having migrated from other states, approached his nearby shop for the entitled ration tickets scheme in the National Food Security Act 2013 was denied the same. Not only that, but also the beneficiary has issued a due slip by the dealer. The dealer found to have denied the service of linking Aadhaar with the ration card and making entries of mobile mom number in the EPOS and reward for the beneficiary. We have been found to mislead him by linking his Aadhaar with so-and-so. Overall violation of the provisions mentioned in para section so-and-so West Bengal Public Law 2024. Well, in terms of this show-cause notice, ultimately a punishment has been imposed. You will also kindly turn to page 15 under 2024 control order. Second paragraph denotes the 2024 control order. You will also kindly come to the last paragraph of page 15. Now, therefore, after careful, kindly see 35,000 rupees has been imposed as penalty.
Yes.
The dealer make payment of such amount. You will also kindly turn page 17 and 18. Page 17 is the acknowledgement by the Food and Supplies Department showing that he has deposited the penalty amount of 35,000 without going to prepare any appeal or something else. This is page 17. Now kindly turn to my lord, page 18. It is not legible. I have given the type copy at page 19.
Yes.
This is 21st of October 2024. The charge which have been given in the other, this is all set. In addition to that, another charge has been framed. That is your lordship kindly review. Third paragraph. Also, he has been found to link his personal mobile number with DRC of Nepal. Have you lordship got it? This is the new one. First one is the previous charge. Now, what is the punishment? Kindly see. Now, therefore, after careful consideration of all factual documents and evidence, the undersigned being the licensing authority exercising upon the power as confined in subclause so-and-so of the principal secretary to the government of West Bengal and Food and Supplies Department is hereby passing the suspension order. No show cause, no hearing for additional charge, suspension. For the self-same charge, first 35,000 penalty, deposition of money. Putting those two charges in addition to another charges without show cause, without opportunity of hearing, suspension. Well, this order has been challenged before this honorable court. During the vacation bench, And your lordship sitting in the vacation bench passed an order of stay extension. Since there is no show cause proceeding. This interim order has been extended time and again. Kindly take note of.
Yes.
I should be candid one, my lord. We have filed a contempt application because the allotment has not been made. State has preferred an appeal. Appeal is pending, no stay has been granted. So, my lord, it has already been given effect. What I want to submit to your lordship, it was the submission on behalf of the learned Advocate General that unless it gives effect, one of my member hall has already faced the punishment. And by virtue of not issuing show cause notice, not providing opportunity of hearing, his license has been suspended. And that has been stayed also. The basic principle of natural justice says a person, even a murderer, should be given ample opportunity to defend his case. I shall show to your lordship the control order, just one provision, penal provision and the appeal provision, which suggests the licensing authority shall issue a letter asking the dealer to come my chamber at about a particular time for personal hearing. Suffice. I shall go there. I have to endorse my signature in the attendance. They will say, they may say, all right, hearing concluded. I don't know why hearing, what is the provision, what is my offense, nothing. After 2-3 days, they may intimate me, your license has been terminated. If this does not violate principle of natural justice, then the definition of natural justice should be changed. Ample power I shall show to your lordship. If I don't respond to their demand, I am just saying, if I don't respond to their illegal demand, my license can be terminated without intimating me anything. After taking the order of termination, I may know these are the charges. So, my lord, the submission which has been advanced by learned Advocate General, that unless it gives effect, mere passing of any legislation automatically does not give any cause of action is not correct. At least one of my member has already faced the punishment.
Yes.
The next submission was, unless an act is declared ultra vires, interim order cannot be passed. And a judgment has been relied upon. I shall make submission so far this point is concerned, relying on the judgment placed before your lordship by the state. In addition to that, another judgment I shall show. So far this part of the argument is concerned, unless act is declared ultra vires, interim order cannot be passed. But thereafter, learned Advocate General read out pair A and E of my petition. So let you kindly turn to pair A and E at page 19. 19A. No, 19. 19. Well, kindly read A and E has been placed before your lordship. Edit in the nature of mandamus, declaring the West Bengal target public distribution order as ultimate to Article 14, 19(1)(g) and 21 of the Constitution. So I paid for washing of this or declaration of the rule as ultimate for violation of Article 14, 19(1)(g) and 21 of the Constitution. I shall show from my petition the grounds Now pair E at page 20. An order to issue staying the operation of the West Bengal targeted public distribution system controller to introduce. These are my main pair in the repetition. The submission was advanced that no civil and evil consequences. Unless there is a civil and evil consequences, there is no scope to entertain this petition and pass any interim order. Now, just 2-3 provisions I shall place before your lordship, did not go through the repetition. I have shown to your lordship definition clause.
Yes.
2K, page 77 of the repetition, did not go through the same, which suggests this person should be treated as family member. 2X definition clause at page 78 of my repetition define the relatives. I have already argued with your lordship shop up of the father-in-law in a distance place. So son-in-law cannot apply. Like that, others. If this provision does not mean civil consequences, attraction of civil consequences, then I fail to understand what is the civil consequence. Next reference I have shown to your lordship, clause 11 Roman 5, page 82 of the repetition, H bar. I have already submitted with your lordship. The discrimination, unreasonableness, unfairness, unjustness, arbitrariness. A person 44, 11 months, 29 days can get a license and can continue up to 90 years. A person only 45 days, 1 day, she cannot, a widow. If this is not unreasonableness, this is not unjust, this is not unfair, this is not arbitrary, this is not contradictory to concept of a statute, then entire such definitions would be changed. This is attract fundamental right to do a lawful business. Both the provisions, 45 years and relative and family members. This is straightway curtail my right to do the business. Right to do lawful business is my fundamental right. This is also attracts Article 14. 45 1 days permissible up to 90 years. No above age limit. This also attracts Article 21, livelihood. These are all fundamental rights. Article 14, 91G, lawful business, 21, livelihood. Resignation part is also there. Doorstep delivery is also there. Now, your lordship, kindly take up my petition, page 102, clause 45. What is the penal provision? Page 102, clause 45. Chapter Roman 9, offense and penalties.
Yes.
Well, first 44 penalties, same as otherwise provided herein below. Whoever contravenes the provisions of this order shall be liable to be penalized under the section 7 of this act. 7 of the act, this is essence of this act. This is one of the provisions. Clause 18 has been legal license may after giving some, then penal action against the dealer for contravention. If a dealer of his authorized representatives or any other person acting on his behalf keep the ration cards, these are the offenses. 1 to 11, 12. For these offenses, what will be happen? Next paragraph. The licensing authority may, after giving an opportunity of hearing, being heard to the dealer and for the reasons to be recorded in writing, impose penalty according to the gravity of the offense as stipulated in part 1 schedule C. So what, again I am repeating, a notice asking the dealer to come my chamber next day at 2 p.m. After going there in front of 3-4 officials and the licensing authority, it is my duty to endorse my signature in the attendance register. And if they say a hearing has been concluded, you may go, you may leave, I have to leave. And after 3-4 days, I may receive a letter whereby I may be informed that my license has been terminated for these reasons. The first time, intimation, these are the charge against you. This is after imposition of penalty, punishment, capital punishment maybe. Only being heard. There is no provision that minutes shall be taken. It should be recorded. At the time of hearing, there should be a recording about the minutes of the meeting. Nothing. If they say we have disclosed all the charges and he has given answer, I have nothing to say. I have never seen in my 30 years of practice that disciplinary proceedings only after opportunity of hearing. Even capital punishment, my bread and butter. If it does not attract 91G, it does not attract 21, then there is no provision which attracts 91G or 21 of the Constitution of India. Now, Your Lordship, kindly see the next paragraph. If a dealer who found guilty of an offense committed under clause 1 is again found to be contravened the same provisions for the second time or third time, the license authority may render his license under suspension immediately and after giving him an opportunity of being heard and for reasons to be recorded in writing, impose punishment of either fine or so and so and so. Again, second offense, no disclosure. Opportunity of hearing, punishment, capital punishment. Now, next one. If the licensing authority on a complaint received against a dealer or suo motu, if prima facie said that such dealer is acting on in such manner which is prejudicial to the interest of the beneficiaries, that with his shop or may hamper smooth implementation of the public distribution or may lead to law and order situation, he may immediately render the license under suspension. Kindly see, my lord, no show cause. Suspension for indefinite period. That I have shown to Your Lordship from the supplementary affidavit. Your Lordship, this is the basic principle. Suspension can be imposed till the disposal of the proceedings. Here is the provision. I can put your license under suspension for indefinite period. Just like termination. And after giving him an opportunity, no time has been given. I found guilty, so and so punishment. So when the proceedings will be concluded, after suspension, nothing has been let down. It can be done after 5 years, putting my license under suspension. Then, my lord, kindly see after dealer, so and so, then, my lord, first paragraph. Public distribution commodities for licensing authority may suspend his license immediately and after giving him opportunity of being heard, it found guilty of such offense and may passing a reasoned order in by passing reasoned order in writing impose a punishment of either fine, reduction of so and so. Again, same thing. This point I am harping. Now, Your Lordship, kindly see the provision for appeal at chapter Roman 12, clause 57, page 108. Chapter Roman 12, appeal and review, appellate authority, appeal. First, clause 56 defines the appellate authority in respect of the dealer and distributor, then, my lord, appeal. A licensee who is aggrieved by an order of licensing authority passed under Chapter 9, Roman 9, may within 30 days from the date of receipt of such order prefer an appeal to the first appellate authority. Now take note of it. When the proceeding was to be concluded, nothing. But I have to prefer appeal within 30 days. You may keep pending the disciplinary proceedings for years together. Now your lordship will be astonished. Kindly see the appeal provision. Roman English 4, my lord. After skipping 2-3 paragraphs, while disposing of the appeal, the first appellate authority or the second appellate authority, as the case may be, has the power to record the license or not to go through. My lord, B, enhance or reduce or vary the penalties imposed upon the licensee. I have suspended you. I have taken some cards from you. I prefer an appeal. Appellate authority may terminate my license in my appeal. This is a threat not to prefer any appeal. This is a threat to the dealers. You have imposed a penalty of 50,000. I preferred an appeal. The first appellate authority found I am more guilty. It would be 50 lakhs. The licensing authority reduced some cards as penalty. I preferred an appeal. The appellate authority may terminate my license. But there is a, keeping in mind, there is a review commission also. In review, they can do it. Kindly see the next review. The secretary may suo motu or upon a representation made on his behalf, call for the records related to the order passed under the so-and-so by the licensing authority, and if he is satisfied that the authority has exercised such power, in play, review such order and pass an order. So this power is there. He may suo motu initiate a proceedings or review proceedings. He may reduce or enhance the punishment. But in addition to that, when the appellate authority has been given a power to enhance the punishment, this is a threat to the dealers. Don't go for appeal. I have never seen these provisions. If I not file appeal, there is no scope for enhance the punishment. So don't go for appeal. Accept the position. Court regularly submits no without statutory appeal exhausting the statutory provision, which cannot entertain the writ petition. Normally, my lord court, not normally, in 190% cases, it's the views of the courts. Unless you exercise your all remedies under the statute, writ court cannot entertain. So I have to, if I agree, I have to prefer first appeal and second appeal before coming the court to take the constitutional safeguard. But this is a threat. Kindly take, my lord, this manner. My license has been suspended or 50% ration card has been reduced.
Yes.
I am not satisfied. What to do? I came before this honorable court, an order has been passed. First file appeal, second appeal, then come. The moment I shall file first appeal, they will say, you have gone to the court. You have huge power. All right. Now your punishment of 50% cards would be 75%. I have again gone to the second appellate authority. If they desire, they may now terminate my license also. And then I have to come before this honorable court. There is no scope for interim order because license has already been terminated. Is it reasonable? Is it fair? Is it just? This is not arbitrary. This is not unreasonable. This takes away my fundamental right to do lawful business. Capital punishment, I will be throwing away my livelihood, taking away my livelihood. If this is not entertained by the court, where I shall go? My learned friend also submitted before your lordship. There is no civil and evil consequences. Just 2-3 reference I shall give you. What is civil and evil? I have already submitted before lordship the fixing of age to apply for license by a family member of the dealer who died after 50 years of running the business, maintaining his entire family. Since his wife or sons, who is only eligible candidate, having no source of income, cost 45 plus, he cannot apply. This is civil consequences. The scheme is there. You have not waived the scheme. Scheme is there. Scheme is there. But taking away my right. Your lordship knows government service 60 years. A person can do the job up to 60 years. A dealer cannot. He can do 80 years. He can do up to 80 years if one day before he got the license.
Yeah.
Resignation, civil consequences. I am suffering chronic diseases. I cannot go to outside my house also. I submitted resignation. This is my condition. These are the medical documents. Wait, run the business. When we shall desire, we shall accept it. Civil consequences. Evil consequences now. Termination of license without any intimation. Power of the appellate authority, enhance the punishment. These are the evil consequences.
Yes.
If this is not civil and evil consequences, then again I am not submitting before lordship, definition of civil and evil consequences should be changed.
Yes.
The last submission advanced before lordship, that there is no constitutional issue has been challenged, no issue has been, no point has been taken. So we are not entitled to get any interim order, or we cannot challenge even the control order, violence of the control order. Kindly take up 2-3 grounds of my petition. First, your lordship, kindly turn to page 17. Ground number Roman 22. No, 17, sorry. Page 7. 17. Yes, sir. Ground. Yes, sir.
Yes.
Roman 17. I am reading well. For that, the clause 46 of the State Control Order 2024 is ultra vires to the Article 14, 91, and 21 of the Constitution of India. Since there is no provision for initiation of penal proceedings by way of issuing show cause notice, asking the dealer concerned to submit reply explaining his clarification position. We have not taken according to the state. Then next one. For that, in terms of clause 46 of the Control Order 2024, the respective dealers will have no option to know the reason for which he has been called for hearing. And actually punishment, including capital punishment, may be imposed upon him or her without any intimation about the charges, which is ultra vires to Article 14, 91G and 21 of the Constitution of India. The fundamental right that has been categorically taken. Submission is that we have not challenged. There is no violation of fundamental right. Next, for that, it is the opposite to the principle of any disciplinary proceeding that appellate authority has been given the power to enhance the punishment, but under paragraph so and so, power has been given to the appellate authority to enhance the punishment, that too without issuing any show cause, which is ultra vires to Article 14, 91G and 21 of the Constitution. What more? I am asking myself, what more? Kindly turn the page. Page 18, paragraph Roman 22. no pleading, submission. For that, under the provisions of Controller 2015, there is no such provision for delivery of ration articles by the dealer to the doorstep of the beneficiaries. However, under clause 17 of the Controller 2024, it has been mentioned that the state government has the power to frame rule for delivery of food grains by the dealer at the doorstep of the beneficiaries, which is ultra vires to Article 14, 91G and 21 of the Constitution. I am adding further line. It is inconsistent with the central control order. All these provisions, the grounds which have been taken for violation of fundamental right protected under Article 14, Article 91G and 21 of the Constitution of India, these are all inconsistent with the provisions of the central control order as enumerated in the State Control Order 2024. The last argument advanced on behalf of Learned Advocate General was the concept of natural justice has been changed recently.
Yes.
Principle of violation of principle of natural justice, if contrary to law, only then court can interfere. Now the provisions have been changed. The Supreme Court says, according to the Learned Advocate General, that show cause proceedings, reply, hearing, submission of documents, handing over inquiry report, these are not required. And judgment has been relied. I shall rely upon the judgment which has been placed before your lordship by the state. The next last argument was how the petitioner has been prejudiced by not providing show cause notice. There are numbers of judgment. I have brought one. No prejudice is required to be placed when there is a violation of fundamental right or principle of natural justice. If it does not prejudice me to intimate me for these reasons you are being terminated before my termination, if it is not prejudice me, then question of prejudice does not, meaning of prejudice will be changed, my lord. Now the judgments which has been relied on behalf of the state, there are 4 judgments. First judgment, you will also kindly take up with 2014, volume 5, division bench. My lord, sorry, my lord, I shall rely upon our judgment, then I shall sort to distinguish. I shall rely upon only 3 judgments. The first judgment I am relying on, 2014, volume 5, CHL, Calcutta, page 277. This is reported in 2014, volume 5, Calcutta High Court Notes, Calcutta, page 277. Paragraph 13 and 14, I shall rely upon. This is the division bench judgment. Just now, it is not possible. May I read and hand over the book? I'm extremely sorry. Supplementary. No. No.
No judgment.
Well, just I'm reading. I'm extremely sorry.
Yes, proceed.
That is there.
No.
I'm reading. Sorry. At least my juniors structure of it. But paragraph 13 and 14. This is a division bench judgment. Justice Nishira Matre and Taposh Mukherjee. Paragraph 13 and 14. Well, your lordship need not go through the paragraph 13 entirely. After 10, 12 lines from left hand side, after 2 words, sentence starts, it is only the locus. Because prior to that, all judgments have been dealt with. Paragraph 13 starts Mr. Chatterjee, then after 15, 16 lines, the sentence starts from left-hand side. After not in question, then it is only the locus. This is in respect of the filing of case by the association. Have you put a mark for it? May I give a marking? Pencil mark. Have you got one? May I take back and give a marking?
It is
Only the
only
locus.
the locus.
Well, I'm reading. It is only the locus of a trade union and its right to file an application on behalf of the members that is to be considered. A trade union, it is now well settled, is a juristic entity recognized as a body corporate under Section 13 of the Trade Union Act. It is entitled under the Act to take up the charges on behalf of the member to redress their grievances by adopting legal means, including approaching the courts of law on behalf of its members. The Administrative Tribunal Act has been enacted to provide for the redressal of disputes and complaints with respect to the service conditions and disputes of conditions and recruitment of persons appointed to the public services and posts in concern connecting with the union and state or any local or the other. Thus, the Administrative Tribunal Act is a piece of welfare legislation available to the employees of the government. There is no dispute that the government employees are entitled to form a union in order to ensure that any injustice done to them is rectified. A registered trade union is enjoyed to protect the legal rights of its members. Therefore, a union must be considered to be a person aggrieved. Can you take note of it? The union must be considered as a person aggrieved, as it acts for and behalf of the employees who are aggrieved. Instead of several employees individually filing proceedings before the tribunal, they entrust the responsibility to their union as its members. Section 19 of must be construed liberally and in the widest possible terms and so and so. Employees cannot be deprived of their rights by raising a bogey of locus standi when their trade union espouses their cause. In the case of so and so, while dealing the Supreme Court, while dealing with the demand on bonus of employees working in establishment employing about 5,000 workers in the same neighborhood, considered the plea taken up by the employees that a union could not be a party to a dispute which is between the workers on the hand and the establishment. On the other hand, therefore, the union had no locus standi. While dealing with the Supreme Court has dealt with it, then kindly turn the page, paragraph 14. In the present case, the union has sought justice for an entire body of employees working in the same institution and who were similarly situated. Thus, in our view, the rights of the employees of TNJ Homeopathic Medical College and Hospital cannot be defeated by the government on the ground that the petitioner which represent the employees did not have locus to file an application before the tribunal, or indeed this petition. We are of the view that the contention of the devoid of substance and therefore it is rejected. But same, we are on the same board, all the dealers, same cause, same impugned action. The next judgment I shall rely upon for Lordship, 2006, volume 4 Supreme Court cases, page 517. This is 2006, volume 4, Supreme Court cases, page 517, paragraph 15 and 16, and 17 also. 15, 16 also. There is a third possibility. This is in respect of subordinate legislature. It was argued before your Lordship that the subordinate legislature cannot be challenged. I am reading paragraph 15. There is a presumption in favor of constitutionality of a validity of a subordinate legislation, and the burden is upon him who attacks it to show that it is invalid. It is well recognized that a subordinate legislation can be challenged under any of the following grounds. A, lack of legislative competency to make the subordinate legislation. We are not. Violation of fundamental rights guaranteed under the Constitution. Article 14, 91G, 21 has been violated. Violation of any provisions of the Constitution of India. Failure to conform to the statute under which it is made or exceeding the limits of authority conferred by the Enabling Act. Pausing for a moment. Central Control Order. Consistency, inconsistency. I have shown at least 3 occasions, 30 occasions. Repugnancy to the laws of the land, that is any enactment. Manifest arbitrariness, unreasonableness to an extent where the court might well say that the legislature never intended to give authority to make such rules. This is also covered by our case, then paragraph 16. The court, considering the validity of a subordinate legislation, will have to consider the nature, object, and scheme of the Enabling Act, and also the area over which power has been delegated under the Act, and then decide whether the subordinate legislation conforms to the parent statute, where its rule is directly inconsistent with a mandatory provision of the statute. Then, of course, the task of the court is simple and easy. But where the contention is that the inconsistency is not conformity with the rule is no with reference to the specific provision of the Enabling Act, but with the object and scheme of the part of Act, the court should proceed with the caution before the so our case, there is a specific inconsistency, I have shown to your lordship. Now, my lord, paragraph 17. In Indian Express, once a case of subordinate legislation does not carry the same degree of immunity which is enjoyed by a statute passed by a competent legislature. Subordinate legislation may be questioned on any of the grounds on which plenary legislation is questioned. In addition, it may also, this has been said that both the act can be challenged. If there is consistency, then Central Act and State Act both can be challenged. We are not concerned about the same. The next judgment, my lord, I shall lay upon my lord. 2016, volume 7 Supreme Court cases. 2016, volume 7 Supreme Court cases, page 703. I have given a para 34 at page 98. Possibly not, page may not be tallied because this is online copy. I have given the flap, my lord. Paragraph 34. 7, no. Paragraph 34.
Yes.
I am reading paragraph 34. In state of Tamil Nadu versus so-and-so, this court, after adverting to the relevant case law on the subject, laid down the parameters of judicial review of subordinate legislation. Same issue. The judgment which are placed before lordship, that has been quoted. The court, considering the validity, did not go through. That has been quoted. Now, your lordship, kindly come to the last paragraph of the judgment. At page 90, paragraph 90. Just paragraph 90.
Yes.
Kindly see the result of the petition. As a result, therefore, we set aside the judgment of the Honorable High Court and allow this appeal, declaring that the impugned regulation is ultra vires to try, act, and violates the appellant's fundamental right under Article 14, 91 of the Constitution of India. This is a subordinate legislation has been challenged, and court has passed an order declaring ultra vires of the Act for violation of Article 14 and 91. This is subordinate legislation. Now, one piece of document I shall present to you, lordship. The policy. My esteemed learned friend, Advocate General, has submitted to your lordship that this is a proposition. So far, my judgment is concerned, I have placed before lordship Brijmohan Lal that dealt with policy decision of the state. I shall show from the judgment that this is not only policy, subordinate legislation has also been taken note of. Before that, my lord, just I shall show to your lordship the definition of policy from Black Law Dictionary. Top kindly see the policy. What is the policy of the state? First,
yes.
Lines, policy. The general principles by which a government is guided in its management of public affairs or the legislature in its measure. But this is the definition of policy. Kindly turn, my lord, public policy after 2 paragraphs. The principle of the law which holds that no subject can be lawful do that which has a tendency to be injurious to the public or against the public good. The principles under which the freedom of contract or private so and so and so. The policy means, my lord, the state how and which manner state will proceed. A benevolent state shall proceed on the basis of its policy. If it is attracts the constitutional safeguard, if it is contrary to the inconsistent to the mother law, then always court has the power to interfere, and court has also the power to pass an interim order. I shall show to your lordship. Well, now your lordship kindly take up the judgment placed before your lordship by the learned advocate general. First, your lordship kindly take up 2004 volume 6 Supreme Court cases. 2004 volume 6 Supreme Court cases, page 254. Possibly my hand. A copy has been handed over to your lordship. But he has read out paragraph layered on paragraph 21. Before that, just brief facts of the case. What is the case? The issue involved in this case is the Locus. What happened, my lord? A central act has been issued.
Yes.
A company of Maharashtra, Bombay, challenged that central act before the court of the High Court. That's the issue before the court. Supreme Court says Delhi High Court has no Locus. Kindly take, my lord, first two paragraph of the judgment. Entirely different issue. I am reading, my lord. SB Sinha J. For the seat of parliament of the legislature of a state would be relevant factor. The territorial jurisdiction of a high court to entertain a writ petition under Article 26 of the Constitution of India. It's the question involved in the appeal which arises of the judgment and order dated so passed by the High Court of Delhi in WCWP holding that the said court has no jurisdiction. Well, that was the issue. Next paragraph. The appellant is a company registered under the Indian Companies Act. Its registered office is at Bombay. It obtained a loan from the Bhopal branch of State Bank of India. Respondent number 2 issued a notice for repayment of the said loan from Bhopal purported to be in the terms of the provisions of the securitization and reconstruction of financial assets and so. Questioning the validity of the said act, the said petition was filed before the Delhi High Court by appellant herein, which was dismissed in ground of lack of territorial jurisdiction. Now, your lordship, kindly come to the paragraph which has been placed before your lordship at paragraph 21. What's the court's observation? I'm reading my paragraph 21. A parliamentary legislation
Yes.
A parliamentary legislation where it receives the assent of the President of India and is published in the official gazette, unless specifically excluded, will apply to the entire territory of India. If passing of a legislation gives rise to a cause of action, a writ petition questioning the constitutionality before can be filed in any high court of the country. If it is not so done, because the cause of action will arise only when the provisions of the act are same that which are implemented shall give rise to a civil or evil consequences to the petitioner. A writ court, it is well settled, would not determine a constitutional question in a vacuum. But this is a central act, new act. If it is state, there will be a vacuum. So for our case is concerned as a subordinate legislature. Even if your lordship pass an order, they may proceed on the basis of the central act. And the issue involved in this case is jurisdiction of the court. Whether central act can be challenged in any high court according to the wisdom of the petitioner or not. Now, your lordship, another paragraph, your lordship, kindly read. Paragraph 22. The court must have the requisite territorial jurisdiction. An order passed on a writ petition questioning the constitution of a parliamentary act, whether interim or final, keeping in view the provisions contained in clause 2 of Article 2 of the Constitution of India, will have effect throughout the territory of India, subject to courts to the applicability of that. Kindly take note of interim order or final order. Both has been taken note of. Now, paragraph, next paragraph. A writ petitioner, however, questioning the constitutionality of a parliamentary act shall not be maintainable in High Court of Delhi only because the seat of the Union of India is Delhi. That authority's office was in Delhi. Taking the same recourse, they have filed the court before the Delhi High Court. Supreme Court says, no, it cannot be. Its effect is all over India. A High Court, a state High Court cannot interfere with the same. In so far our case is concerned, our only jurisdiction before your lordship, this subordinate legislation act has been framed by the state government. Paragraph 24. But kindly state will come to paragraph 30. 30. The last paragraph of the judgment.
Yes.
We must, however, remind ourselves that even if a small part of cause of action arises within the territorial jurisdiction of the High Court, the same by itself may not be considered to be a determinative factor compelling the High Court to decide the matter on merit. In appropriate cases, the court may refuse to exercise discretionary jurisdiction by invoking the doctrine of factor on convention, so and so. But this is entirely in respect of a jurisdiction of a High Court, and also held that it can be entertained by the Supreme Court. It never says court has no power. Next chapter. 2021. Well, these are the only judgment which has been placed before lordship on behalf of the state, that so far the entertaining of the writ petition and interim order is concerned. Now the interim order, they are relied upon two judgments. First, pilot 2021 volume 2 Supreme Court cases. 2021 volume 2 Supreme Court cases, page 785.
Yes.
Paragraph 11. They are relied upon. I am reading paragraph 11. Have you got? May I read my?
Yes.
It is no doubt true that the act providing reservation has been upheld by the High Court, and the interim relief sought by the appellants would be contrary to the provisions of the act. This court in Health versus Williamson Union of India held that courts should be extremely loath to pass interim order in matter involving challenge to the constitutionality of the legislation. However, if the court is convinced that the statute is expressly unconstitutional, kindly take note of. However, if the court is convinced that the statute is expressly unconstitutional and the factors like balance of convenience, irreparable injury, and public interest are in favor of the passing an interim order, the court can grant interim relief. This is our case. Termination without show cause, without intimation, anything. Balance of convenience of inconvenience, already effect. 45 years age. There is always a presumption in favor of the constitutional validity of a legislation. Unless the provision is manifestly unjust or glaring unconstitutional, the court took judicial restraint in staying the show. It is evident from the perusal of the above judgment that normally, this is an abnormal case. Service jurisprudence never suggests, any jurisprudence never suggests a person shall be hanged without knowing what is the charge against him. Even Kassav has been given 4 years time for trial. Lawyer has been provided. A terrorist, hundreds of people died. 4 years his trial has been continued. He has been provided lawyer. I am a dealer. There may be an allegation that you are not giving me ration articles. What the complaint, I don't know. Maybe the other dealers persons. Kindly take note of. The provision gives power that if any complaint is received, we may proceed and even your license can be terminated. Nothing has been intimated who are the complainant. Subsequently, it appears, because there is no provision for showing cause or handing over the complaint or inquiry report. There is no inquiry at all. The persons who have signed the complaint are all separate area, residing in the separate area. At the instance of other dealer, he knows if it is terminated or suspended, these cards will be tagged with me. I don't know even after my termination who lodged the complaint. It should be continued. No interim order will be passed by the court. Now the next judgment I am relying before Lordship. (2014) that has been relied on by the learned advocate general. 2014, volume 14 Supreme Court cases. 2014, volume 14 Supreme Court cases, page 496.
Yes.
But paragraph 13 and 15 has been relied on. Interesting. 13, 14 and 15. 13 I am reading. We have considered the respective arguments and submissions and carefully perused the record. Since the matter is pending adjudication before the High Court, we do not want to express any opinion on the merits and demerits of the petition's challenge to the constitutional validity of the 2003 Act and the rules as amended in 2005, but have no hesitation in holding that the High Court was not at all justified in passing the interim order of ignoring the well-settled proposition of law that in matters involving challenge to the constitutionality of any legislation enacted by the legislature and the rules framed thereunder, the court should be extremely loath to pass an interim order. At the time of final adjudication, the court can strike down the statute if it is found to be ultra-virus to the Constitution. Likewise, the rules can be quashed if the same are found to be unconstitutional or ultra-virus the provisions of the Act. However, the operation of the statutory provision cannot be falsified by granting an interim order, except when the court is fully convinced that the particular enactment or the rules are ex facio unconstitutional and the factors like balance of convenience, irreparable injury, and public interest are all in favor of transfer. That is the total shutdown. In a fit case, court is enough empowered to pass an interim order. Next paragraph, which has been relied on, paragraph 15. I shall read paragraph 14 subsequently. Paragraph 14 has not been relied on. Paragraph 15. A reading of the interim orders leads to no manner of doubt that while granting interim relief to the petitioner, the High Court did not apply its mind to any of the ingredients, the existence of which is sine qua non for such orders. The High Court overlooked the fact that the consumption of tobacco and tobacco products, kindly take note of what was the case, facts of the case, has huge adverse impact on the health of the public at large, and particularly the poor and weaker section of the society, which are the largest consumers of such products, are the unrestricted advertisement of these products will attract younger generation and innocent minds who are not aware of grave transfer. Kindly take note of paragraph 16. The learned counsel for the appellants pointed out that as on date, 10 lakh people die every year due to oral and lung cancer caused by the consumption of tobacco and tobacco products. They further pointed out that as per the study conducted by National Institution of Health and Family Welfare, 85 lakh people are likely to be annually by 2015 due to oral and lung cancer caused by the consumption of tobacco and tobacco products. 17. We have no doubt that the central government and the state government across the country are alive to serious and grave consequences of advertised tobacco and various products manufactured by the using tobacco. They know that the consumption of these products will result in rapid increase in the number of cancer patients, and huge proposition of budget earmark for health of common man will have to be so and so. In the result, the appellants are allowed and the interim order are set aside. In the result, interim order has been quashed and set aside. Why? This is an immense effect. Restriction has been imposed for production, purchase of tobacco and tobacco goods, and not to publish it, advertisement. Interim order has been granted. Supreme Court came to a conclusion. The state and central government has expending huge money. Numbers of people are dying. That should not be stayed unless declared ultra-virus. Is it? Tell you with our case, the facts of the case. Reading one paragraph of the judgment without going through the facts, it is a settled principle of law. each word change the judgments, ratio of the judgment.
Yes.
Keeping in mind Supreme Court under was the interim order. Now the next judgment. Delhi High Court. One single bench judgment of the Delhi High Court has been relied on. Online judgment, 2008 SCC online Delhi. Have you also got it?
Yes.
Paragraph 70 has been read. This is a single bench judgment. I am repeating my. Paragraph 17. At interim stay is not normally granted when virus of provision is challenged. Statutory provisions or even a delegated legislation is presumed to be valid till it is struck down. Supreme Court has not granted stay of the master plan as paid for by the applicant. Supreme Court has refused to pass an interim order. Then High Court case has been filed. Prayer for interim order has been sought for. That has been rejected. And this is a single bench judgment. I am not saying only it is not binding upon me. Single bench and other state. And that too, my lord, it does not say the contrary to the Supreme Court that in a fit case, interim order can be passed. My learned friend has relied upon a judgment reported in 1999, volume 1, Calcutta High Court notes, page 521.
Yes.
The submission on behalf of the learned state advocate was Advocate General that nowadays concept of principle of natural justice has been changed. In support of that recent judgment, he has relied on a 1999 judgment, 25 years back. Natural justice was previously show cause, reply, hearing, supply of documents, inquiry report, but at present it is not required. In support of that submission, a judgment of 1999, meaning thereby 25 years there. Now I am reading whether this judgment helped me or the state. Kindly read, my lord. Paragraph 21. He has been relied 21, 33, and 34. Paragraph I am reading, paragraph 21. Or may I read paragraph 21? It would follow.
Paragraph 33 and 34 has been.
I'm wrong. Absolutely right. Paragraph
33 and 34.
What is the procedural length of kindly? The express procedure is specifically provided by Rule 28 of the Management Rule as clarified by the notification issued by the West Bengal Board of Secondary Education. Although we have dealt with the express steps emphasized in the connection with the first two questions framed, nevertheless, it would be inconvenient with the fact that two questions framed. Nevertheless, it would be convenient to recapitulate the same briefly for the purpose of science. So, what was the procedure? Kindly read. The first stage of disciplinary proceeding requires the managing committee to draw formal proceedings. Issue of, this is by pair, issue of charge sheet to the delinquent. Offer the delinquent reasonable facilities for defending himself. Grant the delinquent an opportunity to submit his explanation within a fortnight from the date. Consider and take a decision on the basis of the material. Send all relevant papers, including the charge sheet, explanation submitted by the delinquent, and the reasons for the decision to be so and so. My pair, I mean, let them do this. If the board approves the decision of the managing committee to take disciplinary action, the second stage of the disciplinary proceeding commences. At this stage, managing committee must issue a show cause notice, second show cause notice to the delinquent ordinarily within fortnight why he should not be dismissed or removed so and so. Before giving the punishment, give the delinquent an opportunity to submit an explanation. Second time, take a decision on the action proposed to be taken. Send all relevant papers, including the explanation submitted by the delinquent as well as the recommendation for the action proposed to be taken to the board. If the board approves, may not approve, the decision of the committee with regard to the action proposed, the managing committee can remove or dismiss the delinquent. Read paragraph 34. The implicit rules of procedure which complement the express procedure follow from the press in Rule 28 of the Management Rules, which requires the Managing Committee to offer the delinquent reasonable facilities for defending himself. In other words, the procedure adopted must conform to the principle of natural justice, but ultimately the best is one of the prejudice, that is whether the person has received a fair hearing considering all things. Next, kindly read my paragraph 35. The procedure which have been considered sufficient compliance with the requirement of reasonable opportunity of defense have been laid down in so. Paragraph 36. Briefly speaking, this would be included as far as for the person is concerned. The giving of a clear charge sheet, providing of facilities for inspection and taking copies of the documents upon which the managing committee relies, granting an opportunity to the delinquent to cross-examine the witnesses. Take note of. Examined by the managing committee and the right of examining witnesses in his favor. Paragraph 37. The implicit procedure also includes the right of the managing committee to delegate the function to so and so. Last paragraph important. However, when the matter is so delegated, the delinquent is entitled to a copy of the inquiry report of the inquiry officer before the disciplinary authority takes a decision. Then kindly take paragraph 40. Next page. If the disciplinary authority differs with the view of the inquiry officer and comes to a different conclusion, the disciplinary authority must record its tentative reasons and give the same to the delinquent so that he has an opportunity to represent against such tentative reasons and in pursuit the disciplinary authority to accept the favorable conclusion of the inquiry officer. Paragraph 41. The managing committee must then take a decision by recording its reasons, which should indicate how it came to the conclusion for taking disciplinary action against the delinquent, and such reasons must be supplied by the managing committee to the delinquent. Similarly, in the second stage, after the delinquent is given the opportunity of responding to the proposed punishment, the managing committee must give its reason in the support of proposed punishment and supply the same to the delinquent. Finally, the West Bengal Board of Secondary Education would have to grant or refuse approval of the decision of the managing committee at both stages on the basis of the materials on record without considering insurance. So this is my fear. This is my fear. There is a check and balance event, two separate authority. Managing committee shall proceed, take a decision whether they will proceed or not, send entire documents to the board, different authority. After taking note, they may start the second proceedings. Show cause, reply, witness, documents, all has to be supplied. How this case support? In my case, ask by chamber. Put your signature in the register book. Go home. After 3 days, your license has been terminated for these reasons. I have not gone through this judgment, Mr. Advocate has submitted on data. Paragraph 10. Today, one judgment has been relied on. So, can you take that? 2004. Yes, just I am reading, I don't know whether I can give a proper answer. Even if a statute is silent and there are no positive words in that, not at all.
Give me a copy, please.
Oh, tiny. May I get only 5 minutes time, my lord, any day? Just only for that. Just. But last submission would be, my lord. It was argued on behalf of the state that Withdrawal sought to be distinguished by saying that it has dealt with the policy of the state, not the subordinate legislation. You will kindly once again take, my lord, paragraph 100 of the judgment. I have last occasion I have handed over Withdrawal. Whether it has been dealt with the subordinate legislature or not, this just this to show you, Lordship.
About the policy decision of the state, it has
Yes.
been argued by the
Yes.
learned advocate general.
This is not subordinate legislation. Now kindly take up paragraph Roman 6. 100 subparagraph 6. if the delegatee has acted beyond the power of delegation. My case is that you have been given empowered to frame a rule in accordance with the rule 2015. It says if the delegatee has acted beyond, then Malak kindly take up paragraph 101, last 3 lines. Law and policies expanding beyond the have you lost your minute? From bottom 3rd line,
Yes.
paragraph 100. Law and policies expanding beyond the permissible limits of delegated power will be instances where the courts will step into interfere with the government policy. This is my case. Beyond the scope of 2015 control order, inconsistent. So, Malad, I am not praying for to interfere with the age. So, for application for dealership on compassionate ground, I am not paying any stay. So, far the other parts are concerned. Today, I am only harping the point of punishment.
Chapter 9. Chapter 9.
Chapter 9. There are instances which is contrary to a central control order. There are instances violation of fundamental right. That is page 40, age 45. Card number of cards. So many things that will be considered after eligibility. I do admit, but so far this punishment part is concerned, I am paying for an stay of operation of court.
তুই 5 মিনিট নেবে আর কি না? এই 5 মিনিট নেবে। সেটা না থাকলে it is inherent. Natural justice is inherent in statute. না থাকলেও it is.
May I read my that will be great to conclude the submission.
আমাদের তো একটা দিন নিতেই হবে। তোমাদের নতুন জাজমেন্ট দেখো।
আমি নতুন করে দেখি। আমি সব ডিস্টিংগুইশ করলাম।
নতুন
ডিস্টিংগুইশ করলাম পর জাজমেন্ট। আমি তো কোনো নতুন ফ্যাক্টসে বলিনি। I have only distinguished.
If Mr. Shahara wants to take another day,
No, I'm
Lord,
not taking
I will not object to that. But the only thing is that in reply he has shown some judgments.
Only to distinguish.
Maybe, but those itself are distinguishable and not applicable to our case, Malad. So, Malad, those have to be dealt with, Malad. The new decision shown today. Yes,
Because all judgments have relied on
Malad, I understand.
to distinguish the judgment relied on by the learned advocate. I don't after reply.
Distinguishing is one thing. Showing judgments. You
have taken the plea of materiality at the very.
Mr. Shahara has very cautiously chosen the judgments shown today because your lordship will see the line. Those are on subordinate legislation because we took the point that Brij Mohan is not covering subordinate legislation. He has shown 2 judgments today. Both are on subordinate. The try as well as the other one. I can deal with it today itself. But Malad, it will be Malad preempting the learned advocate general who is making submission in the matter, Malad. I do not mind Malad making submissions today and concluding it. If your lordship so desires that not to linger the matter, Malad, I can distinguish it today. There is no difficulty with that. Or your lordship may give 5 minutes to the learned advocate general, he can conclude it.
Then it would be appear on 23rd. Prior to that, it cannot be possible. Next week, I am not there.
Tomorrow, 5 minutes.
Tomorrow.
Tomorrow.
Tomorrow, I have other determination.
3:30
কালকে অন্য থার্সডে কালকে থার্সডে ওরকম হয় নাকি একটা কমফর্টেবল
I am praying for a meeting orders for that matter.
Just
So should not have shown judgments,
Vishwanath,
new judgments in reply.
আমি কোনো judgment-ই দেখাইনি।
just কালকে কি আছে সেকেন্ড হাফে? ও কালকে সেকেন্ড হাফে তো ডিভিশন বেঞ্চ আছে। আচ্ছা ডিভিশন বেঞ্চ কালকে ফার্স্ট হাফে কি আছে গো?
Only 15 minutes will suffice. I shall take only 2 to 3 minutes. So far, this judgment is concerned.
The remaining 12 we will take.
কি সেকেন্ড
It can be fixed mallet at 1 PM also.
যখন যা ইচ্ছা।
ফার্স্ট হাফে কি আছে?
Mallet only at 1 PM.
গ্রুপ 6 এর পাঠান ম্যাটার গুলো আছে। ওকে। Tomorrow 12? Tomorrow 12 no? Very good.
12:30 possible, my lord. Because
12:30.
we shall not take, possibly he will take 10 minutes, I have 2 to 3 minutes.
Very good. 12:30. 12:30.
Top of 12:30.
12:30.
This is our topic here.
Marked as to
Okay.
Grateful.
get to us.
Please take down. Argument on reply on behalf of the petitioner heard in part. Let the matter appears in the list on tomorrow, that is 12th of December at 12:30
You should অন্য কোথাও একটা meeting miss করবো।
as a specially fixed matter.
I'm getting much appreciated. I'm for the petition, I understand. I have concluded myself. No. I have concluded my submission. Now, may I just come back, my lord?
Yes.
They don't.
তুমি বলো, আমার অসুবিধা নেই, বলো। তুমি যদি আজকে বলো তাহলে আমি ঘুরে আসবো, এখানে যাচ্ছি তাহলে আমি ঘুরে আসবো। হ্যাঁ।
Yes.
Yes. Well, already last time Mr. Sara concluded his argument.
Yes.
Now, my lord, I start from my argument.
You are appearing on behalf of the private respondent.
I was on 6. I am led by Mr. Basu. He is coming. I am. Oh.
Already come. Yes.
No, বুঝি।
Which are as contents. The main contention of these, if I have understood correctly, but I have not find any pleading of bona fide on the part of the selector. He is endeavor to convert this court to an authority to decide the comparative credentials. Whether that is permissible in the rate question, and I will come to that part later as I to judgment for even if the court is not having power to decide and to weigh the respective credentials, but if court finds that it is glaring on the face of it, then the court can intervene. My endeavor will be to show to your lordship that here the authority has decided comparatively and said that these are the difference between the two candidates. Another point I want to canvass here, my lord, here you will also find, go down to the office. The office of the lead petitioner is not within the parameter advertised. So he is lacking the initial, my lord, there is no comparison there. If he is not having the minimum, if he is not having the minimum requirement, then my lord, his candidature cannot be considered at all. Even for the purpose of weighment of the respective cases.
Yes.
Yes, my lord, I have seen that you have also taken note and asked Mr. Rai that what is the size of your office? And they have not denied that this is actual state of affairs. My lord, so far as the submission made, I will not take much time of your lordship. Whatever submission made by my undertaking is concerned, your lordship kindly, he said that page 24 of the writ petition kindly comes. The application on that basis requirements has been mentioned. To that manner, state has filed an affidavit. Yes. Kindly come to para 8 of the state's affidavit at page 5. His first contention that I have not submitted the documents along with my application. This is the case made out in the writ petition.
Yes.
To that, his submission that I have not filed. To that, kindly produce the state affidavit. What is para 8 of page 5? It is stated that inquiry intimation was given against to the respondent number 6 through online mode by the inquiry officer, and accordingly, respondent number 6 had submitted certain documents for the purpose of inquiry. Photocopies of the documents submitted by respondent number 6 consist the bank details submitted by respondent 6, bank statement, axis bank, whatever necessary, all has been filed in the state affidavit. The first contention that I have not filed the document along with my application, by which my entire application should not be considered, is belied. State is the best person to see whether this is a document uploaded or not. Categorical statement of the state is paragraph 8. State affidavit will give paragraph page 18 also. It can be seen that all documents were supplied. Otherwise, it have been disqualified on that day.
Name letter who is same language.
Kindly then kindly come to paragraph page 18 of the state affidavit.
Yes, 36 of the same document. Inquiry agreement.
Page 18.
Yes.
This similar document has been annexed by the writ petitioner at page 30 of the writ petition. So on that day, both the applicants were considered. And can take a note that at page 30 of the writ petition, the same document, identical document, in the name is different, has been sent to both the applicants.
That is the acknowledgement receipt.
Yes. No. This is to ensure that an inquiry into the application.
That is the enquiry.
Yes.
Enquiry, date of inquiry.
No, inquiry notice.
Scheduled to be held on.
Right. Why I am submitting this? Inquiry, my filed an application, if the application is defective, cannot reach to the stage of inquiry. As Mr. Sahara is submitting that I have not uploaded all the documents, so my candidature should be cancelled at the threshold.
Yes.
To that part we want to show to your lordship that authority has considered all the applicants' application and having found in order in terms of the notification, issued notice for inquiry. So I crossed the first stage.
No, Mr. Sahara argued that on the date of inquiry, the state respondent has allowed the private respondent to submit certain documents.
I will answer to that.
This is the argument. That's why he is saying that these documents are never filed or never.
Can be negatively proved.
Yes.
Yes.
This is the argument.
I will answer to Mr. Sara's contention that on that date I also filed document. I also say.
Yes.
Use the word I also, whatever they have asked for. But the moment the inquiry notice was sent to me and to Mr. Sara's client, both the applicants are correct vis-a-vis the requirement.
Yes.
That's why inquiry was proceeded. Otherwise, at the threshold, it should be rejected.
Your submission is that after acknowledgement of the application, when the authority has considered and issued the notice for failed inquiry, all the criteria of submission of documents along with the application has been completed.
Complete. On that day. Otherwise, my lord, on that threshold, it should be rejected. Not to go for inquiry.
Okay.
As both are, my lord, now we can you see what is the notice? What is the notice was asked for? Date is 23rd October at 9 AM. My lord has said. Then, therefore, you are requested to remain present at the aforementioned venue at the said schedule with original copies of all required forwarded documents as per provisions of 2013 control order. So, it is on the date of inspection, the authority under the statute is authorized to ask for documents. And both of us was directed to produce the documents if at all necessary for them. But whatever I have downloaded, if I don't have the original copy, I will reverse. That's why to cross check. And my credentials are correct. The 2013 control order given the power to the inquiry officer to look into it. That's why they ask it. And I have produced. Yes, I have produced. If he asks, I have don't produce, I will be rejected.
All the persons, all the applicants are given opportunity to produce the documents and the corroborative documents.
Otherwise, it cannot be cross check. Whatever I have said, that is not accurate.
Yes.
Then, my lord. Then another point is said, my lord, the respondents number 6 go down situated at Andi. My lord, your lordship will find that page 31 of the opposition, my opposition, your lordship will find. We come to page 31.
Of your opposition. Page 31.
Kindly come to left hand side. 0.70 jail number, body here. This is not on. So this is the another fault was tried to be found out from my credential. That's why I produced this. Second also, my lord.
So this is of different Mauja.
Yes, Punjab wisdom and Bodiyam. Within the my lord, declared zone, advertised zone.
Advertised location.
Next is land conversion certificate.
Yes.
And you see that page. Same page. This is the 4C conversion.
Yes.
And the top 105 in terms of the provision laid down in 4C. Now it is in Tanga. Classification as per R1 and classification which permission accorded VT converted to VT. So this is also my lord. I am only responding what he has said to find out lacuna on my credential. Then my lord, this also goes. Then, well, I am carrying a fertilizer business, that cannot be a pointer to hold that I am eligible. There is no bar. There is no bar in the 2013 control order that I cannot operate. There is a different judgment that in addition to that I will rely.
candidate.
Oh,
Candidate, same point. Same point.
The point which I have canvassed by the 2013 control order does not preclude me from doing another business. That point was canvassed before the report was not, and the judgment was delivered. Page 16 is judgment was annexed. Division bench held that there is no bar.
Page
16 it starts.
page 16.
11 portion, if you look, kindly come to paragraph 11, page 20.
Page 16 is the single bench.
No, page 16.
License capital
16 bench, division bench, my lord.
21 start.
Sorry, kindly come to page 21. Single bench will not be seen.
Yes.
The notification was cancelled. 21 kindly come to, now kindly come to paragraph 11, page 25. The court also found that the notification is silent about the person already carrying on business and earning a substantial amount of money therefrom. This court is of the view that the judiciary does not legislate or interfere with the policy decision of the state, except which such decisions have the effect of extinguishing existing rights or have civil consequences on persons who have altered their position on the said benefits of the earlier policy. That is section 115 of the Evidence Act. This is not 11 CA. Then my lord court has found out, so no, there is no bar. For that, my lord, according to me, the judgment may not be necessary because statute does not say so. Control order has not prohibited me from doing any other business. Bank balance. Here also, my lord, he is doing the same this business from where he was doing it earlier. Same.
Yes.
Now, my lord, the last point is admitted. It is admitted fact that kindly come to page 7, para 12 of the state review.
Yes.
In accordance to the inquiry report of the inquiry officer, the subdivisional controller food and supplies Standi had selected expert number 6 as the most eligible candidate, and the same had been forwarded to the district controller food and supplies Murshidabad. It is pertinent to mention that expert number 6 scored 70 marks out of 75 marks through the online mode. However, it is to be mentioned that as per the inquiry report of the inquiry officer, the subdivision controller food and supplies Standi classified the petitioner as eligible but not recommended, and the same had been forwarded to the district controller food and supply. It is pertinent to mention that the petitioner secured 63 marks out of 75 marks through the online mode, as his proposed cell counter is less than 20 square feet, 200 square feet.
Speaks with confidence.
Here my submission is, if he is not having the basic requirement,
Yes.
then can he challenge any others credential?
Yes.
In only one eventualities he can challenge. If I also having the same 200 square feet of office space and it has been relaxed, he can challenge. But if the basic requirement he is not processing through, then my lord, he cannot challenge other credentials. These are all facts, my lord. I have nothing more to add. The judgment, my lord, I am relying on the judgment annexed to my affidavit. The judgment, all the points are covered there also, including the points regarding PPS. Kindly come to, and once I will travel to Lordship, kindly come to page 22 of my affidavit. Page 22. Bottom paragraph 6.
Yes.
He submitted that the appellant has been running a fertilizer business and even otherwise does not have the required godown space, as mentioned in the notice inviting application. It is also alleged that the lead petitioner was a better candidate than the appellant. After scrutiny of applicants, the appellant was found to have secured 75 marks and the lead petitioner secured 45 marks. Consequently, an allotment order was suggested. So this is the finding.
Yes.
And the go down, if I am running another business, that is not bad, that is also decided here. Nothing more to add. Now, one or two judgments I will cite for your consideration. And in fact, 2019, please.
দাঁড়ান তাহলে দাঁড়ান আমি
2019 three Supreme Court cases, 352, para 38. This is a body which, according to us, one of the controller is the expert. There cannot be any dispute about it. Keeping in mind, one can read paragraph 38. MERC is an expert body which is entrusted with the duty and function of the same regulations, including its terms and conditions for the determination of tariff. Court, while exercising its power of judicial review, can step in where case of manifest unreasonableness or arbitrariness is made out. Similarly, where the delegate of the legislature has failed to follow statutory procedures or to take into account factors which it is mandated by the statute, consider or has founded its determination of tariffs or extraneous consideration, and court in the exercise of its power of judicial review will ensure the statute is not breached. However, it is no part of the function of the court to substitute its own determination or for a determination which has made by an expert body after due consideration of material circumstances. I repeat, there is no malafide alleged. I will cite one judgment where says if this malafide is alleged and proved, yes, court can.
Yes.
I mean, on this point, my lord, I will only one, I will multiply. 2008, 14, page 306. Paragraphs 24 and 26. You should want to corbo. 2008, 14,
না এইমাত্র যেটা করলেন
page 306. So kindly come as well. What is
Paragraph?
20?
Yes.
There is another aspect of this matter It is also relevant for proper decision of this appeal. We have already indicated earlier that the Board of Appointment was constituted parts in this line by the legislature. They have considered not only the candidate of the applicant and his experience as a lecturer and research assistant, along with others, come to hold that it was the applicant who was the candidate who could satisfy the conditions for appointment to the post of probation. That being the selection made by the expert body, it is difficult for us to accept the judgment of the High Court when we have failed to notice any malafide attributed to the members of the expert body in selecting the applicant to the said post. There is no allegation of malafide evil. Proof is far less. And it then come to 26.
Yes.
Admittedly, there is nothing on record to show any malafide attributed against the members of the expert body of the university. The university authorities had also before the High Court in their objection to the writ petition taken a stand that the appellant had fully satisfied the requirement for appointment. In this view of the matter and in the absence of any malafide either of the expert body or the university authority, and in view of the discussion made here above, it would be difficult to sustain the order of the High Court as the official court and cannot be said to be illegal, invalid, and without basis. This is the test meanwhile submitted, and here but not neither against any allegation against the state of malafide, not against the body who has inquired. Because the inquiry officer report is sine qua non to recommend or not to recommend. And the lastly, I will cite 2008 4 Supreme Court cases 171. I'm saying for the take a note, I cite 2008 4 Supreme Court cases 171. It is for the proposition that if a person is unsuccessful, he is not having the go down, the minimum qualification he is not complying. So he cannot challenge others. This is one of the unreported judgment. As usual, my lord, all child matters clear, sir, is Mr. Sara. He is also here.
So for the respondent.
Obviously, he is there. Can you see the second paragraph? It says on the date, cut-off date, he was not having. So his basic criteria not fulfilled. It's totally correct. MAT 1354 of 2022.
Yes.
We come to paragraph 6. That a township for the state had filed a report to show that on the cut-off date, the petitioner applicant though had balance of rupees 5 lakh or not in his account, but he had not maintained the balance since 1 year preceding the cut-off date. On the other hand, the private expense was 7 in 2 accounts, and as such, he has yet tried to defend it. Now, my lord, kindly come to paragraph 9. Before proceeding to discuss the submission advanced by the landed council parties, let us make it clear that the applicant who is otherwise ineligible has no right to challenge selection of another on the ground that the person selected also had no eligibility criteria. Such a petitioner, if he wants to succeed in a petition, has to establish by pleading and document that he or she is also otherwise eligible, but his or her case has not been considered favorably, and provisions of Article 14 come into play on that score only. Here I repeat, my lord, pardon me for repeating, his go down is less than the requirement. So in any event, he is unsuccessful. He cannot challenge. This is, my lord, the judgment of this court. This 2008 4 Supreme Court cases 171. I am not saying this will suffice. I will not multiply burden on your lords.
Yes.
That's all. Dear my lord, this writ petition cannot succeed Because the comparative evaluation done by an expert, no bona fide alleged. So that is one part. The court will not cannot sit an appeal of this finding, and apart from that, he is ineligible. We cannot challenge other people.
Yes, for the state. Yes.
Lordship, I am appearing on behalf of the state respondent. Lordship, the first and foremost discrepancy is that the petitioner has not challenged their rejection. They have challenged why the private respondent have not challenged why they were rejected. The first ground for rejection, Lordship, if kindly comes to page number 39 of the report filed by the state, Lordship.
Page 39.
Yes, Lordship, page 39 of the report filed by the state. Pardon me, Lordship, it starts from page 37. It is the inquiry report of the petitioner, Lordship.
Yes.
So, Lordship, if kindly comes now to page 39, Lordship. Clause D, pardon me, Lordship, clause C, size of the sales counter. The inquiry report shows that the area of the petitioner is 122.44 square feet. Lordship has found it, Lordship?
Yes.
Now, Lordship, if Lordship kindly compares it to page number 31 of the writ petition, Lordship.
Yes.
39 ही तो बोलेছে হ্যাঁ না ভুল বলিনি আমি ঠিকই বলেছি 39 বলেছি 31 of the writ petition, Lordship. This is the plan which they have submitted. Here, Lordship has found that one word is written office, just above the diagram. Measurement, one side it is written go down, another side it is written office. Just below the office, they have given the measurement of the office to be of 240 square feet. Lordship has office area. Area of the office, they have given just below that 20 into 12 equals to 240 square feet. This is a false statement on the face of the record. Now, the eligibility criteria, it specifically says that 200 square feet is the mandatory requirement. One has to be eligible for qualifying is 240 square feet. So here, the statement made by the petitioner, they are saying that it is 240 square feet, but the inquiry report says that it is only 122 square feet. So on the base of the record, it is a false statement. Now, in regard to the land lordship, if Lordship kindly comes to page number 41 of the report. Lordship can see these are some pictures, photographs which have been annexed. pardon me, Lordship, 41, Lordship, if Lordship kindly comes to 41, the statement which has been made by the inquiry officer in regard to the inquiry of the petitioner.
Overall comments.
Yes, overall comments. It has been written that objection is, but the applicant is the owner of the godown. Overall positive recommendation, but no objection is missing from the mine is not very clear, of the landowner. I think from the landowner as per the ROR. So admittedly no objection. If Lordship kindly now comes to page number 44, this is the documents which are been produced by the petitioner in regard to the ownership of the land. Now here the owners are being recorded as Abu Jalal Sheikh, Hilal Sheikh. Page number 54. If Lordship kindly comes to page number 54 of the report. Have Lordship?
Yes.
Yes. So here the no objection. Admittedly, they are the owner. Petitioner is not the owner, but the no objection certificate has not been submitted with the department by the petitioner. Now, in regard to one of the allegations which has been made by the petitioner, that the private respondent is running a business, and accordingly he is not unemployed, and so he is not eligible. If Lordship kindly comes to the notification, page 11. Clause 3. Pardon me, Lordship, clause 8. Page 11, clause 8 of the report, Lordship. So here the criteria is the applicant should not be involved in some government job.
You are referring
clause 8, page 11, clause 8.
Yes.
Applicant in case of individual should not be employed in any government, semi-government organization, school, and should not be an elected member of any Panchayati Raj institution or urban local body. So there is no mandate that any person who is having another business, he cannot apply. The only mandate is that he cannot be involved. These are the criteria. So it is not a mandatory clause that one has to be unemployed to make an application. The fourth is the license, Lordship, was issued on 7th of August 2023, which is evident from page 68 of my report. But the petitioner chose to sit tight for 2 months. Then he came up with this writ petition objecting to the appointment of the private respondent, but not objecting the grounds, the clause on the basis of which he has been rejected. So there has been a gap of 2 months. He was sitting tight over that issue. Now, in regard to the construction also, Lordship, I have shown the photographs of the writ petitioner's building. It is incomplete. Then the third is in regard to the inquiry notice, which was in the last occasion, I believe it was asked by Lordship also, that whether any documents were submitted later on by the private respondents or not. So in this regard, Lordship, if kindly comes to page 36 of my report. This is the inquiry notice to the writ petitioner. So here, if Lordship kindly sees that last 3 lines, therefore you are requested to remain present at the aforementioned venue at the said schedule with original copies of all required corroborative documents as per provisions of WBPDS Order 2013. So this is not, there is no discrimination in regard to this. The petitioners were also given the same opportunity as well as the respondents. The same notice was issued. And the final argument which I want to make is that Wheat Court has got limited jurisdiction in regard to the administrative decisions taken by the government authorities. Lordship, there are several judgments in this regard, Lordship. If Lordship desires, I can place it also. But this is a settled principle that this is a purely administrative decision that who should be selected a better candidate for a government tender, wherein the only concern should be is there the procedure followed is arbitrary or not.
Yes.
I rest my submission.
Seventh of January.
Grateful, Lordship.
Please take down. Argument on behalf of the private respondent and the state concludes. Let the matter be fixed for reply on behalf of the petitioner. Let the matter appear in the list under the same heading on 7th of January.
Grateful.
Same position.
Same position.
Hardly any time.
Started my submission, but could not conclude. This is a case for violation of principle of nature. Focus notice, 12 pages reply detailing the allegations of 12 consumers. Inquiry has been conducted behind my back, allegedly in the house of the consumer. 12 consumers says they are not receiving the quota as per the scale. I given in my reply all the slips uploaded from the deposit machine showing that entire scale has been given to them. Total 18 pages reply, hearing, one paragraph conclusion. Well, actually, kindly take first one at the show cause notice. Page 30. It is 27th of January 2023.
Yes.
Kindly see, my lord, in every paragraph of the table, the card number has been given and saying receiving 18 taking instead of these are the allegations. This inquiry has been conducted in the house of the allegedly in the house of the because I have no knowledge. Kindly turn to page 31 up to the table 12 name now last name is Mubarak Hussain.
Yes.
Accordingly, my lord, suspension order has been issued. I have been directed to submit my reply under 2013 control order. Kindly take up my reply at page 33. It is 1st February 2023. Starts from page 33. turn the page every allegations in respect of 12 consumers. Your Lordship, it will appear from page 36. What paragraph? 36. I say that so far the consumer, namely Inconsistency, is concerned.
Yes.
It has been alleged that he has been received transfer instead of transfer. In this figure, I say that the Inconsistency transfer received transfer rights and transfer quit by using the mode of other authentication through EPOS machine, which is recorded in the EPOS machine. Copy of the EPOS machine enclosed, along with my reply. Like that, my Lord, kindly see that after 2 paragraphs, I say that so far the consumer name Shahir Ali concerned, EPOS machine uploaded copy also enclosed. All the allegations with specific denial that I have not done so, I have given the same. It is appearing from the EPOS machine. So kindly turn to page 40. It starts from page 42. All the copies I have also from the EPOS machine on the particular date. It starts from 12 pages. All that I have annexed. Did not go through the entire thing. You will have to kindly turn to page. All documents I have annexed. Page 53.
Here.
The consumers have written a letter addressing to the sub-rationing officer. This is urban areas at that material point of time. This is that we are getting, there is no allegation, we are getting our scale, rationalities according to the scale, second paragraph, signed by numbers of consumers. Then His Lordship kindly turn up the hearing proceeding at page 67. Sometimes we see that during the course of hearing, allegation is accepted, whether not denied by the dealer. In this case, bold denial. Page 67. I'm reading, my lord.
Yes.
আপনার নাম কি? নাম has been recorded. আপনার দোকানে কোন পদে অধিষ্ঠিত? দোকানের সেক্রেটারি, is the consumer cooperative society. আপনার সেক্রেটারি বর্তমানে নেই, পরে লিখে দেবো। আপনি জানুয়ারি মাসে এবং আগের কয়েক মাস গ্রাহকদের দ্রব্যাদি পরিমাণে কম দেন কেন? আমি কম দিচ্ছি না। যে প্রাপকগণ কম দেন বলে অভিযোগ করেছেন সে ব্যাপারে আপনি কি বলতে চান? অভিযোগ সমস্ত মিথ্যা। আপনার কি এর বাইরে কিছু বলার আছে? আমার যদি কোনো রকম ভুল হয়ে থাকে, that is the last sentence. Then kindly turn to page, my lord, 68. Lordship, kindly read, my lord, what the facts have been stated. First paragraph, whereas the view to transfer, whereas on the basis of the complaint, whereas the reply is not satisfactory, whereas the copy of the amount, kindly see, whereas the copy of the anomalies of the crime herein is also untenable transfer. Therefore, understanding the exercise of the power delegated by Controller Order 2023 do hereby pass an order of termination. My specific case, reason is the heart of the decision. 18-page reply, every allegation, there is no consideration, not a single line, nothing has been whispered. Why they are accepting the views of the inquiry? Why they are disbelieving my statement? I have given with supporting documents. Not a single line has been spared.
Only the
Last paragraph. Yes.
the reply and anomalies at the time of hearing is also untenable and illogical. Only this sentence has been.
Why it is untenable? I have given the document. Are you disbelieving the EPOS machine uploaded document? This is also preserved by you in your office. They are not saying the documents which have been supplied. This is not the original document. They are also purchasing the document in the headquarters. They can also upload it the same. No copy of the complaint, nothing. Then the next page, my lord, first appeal. Page 69. Brief facts have been stated. Kindly turn to page 75. Bottom portion, grounds for challenge. I am reading 2-3 grounds. At page 75, first appeal grounds. Grounds for challenge. Have you also got at bottom?
Yes.
Natural justice always suggests and prescribes that the incumbent concerned against whom any proceedings is drawn up should be given reasonable opportunity to defend his case by providing all the materials relying on which charges have been framed. In the instant case, proceedings has been drawn up against me relying on a report of the Joint Inspector team. However, in a deliberate manner, a copy of the same report has not been supplied to me with the utter violation of the rule of natural justice, and by this way, my right to defend my case has been taken away. Order of Prime Minister. From a perusal of the order of penalty punishment, it would be apparent that the same is non-speaking, unrealistic, and cryptic one, and not a prudent man can understand on perusal of such order as to which manner reasoning officer Shipur came to a conclusion that the charges leveled against me has been proved. None of the contents of my reply has been dealt with and are considered, and no findings has been recorded in the said order of termination as to why the reasoning officer Shipur disbelieved my statement and accept the complaints of the fake book also. So, report has not been supplied to me, complaint has not been supplied to me, then being the licensing authority who has acted in constitutional authority should have come to a decision independently and impartially, but from the recording of the order, it does not appear that the licensing authority acted independently and impartially. That the licensing authority in the order of termination even did not bother to provide any reason as to requirement and required ingredients to be terminated the license. That since the order of termination is shockingly disproportionate, that since the termination of this has civil and civil consequences, the licensing authority ought to have taken proper care that the license, these are my grounds. Kindly take up the final order of the first appellate authority. Kindly see page 17.
Applying of inquiry report.
Yes. After termination. Yes, at the first appellate authority. If the foundation goes, superstructures falls automatically. Termination done without supplying copy. Since I have taken a point in my first appeal, they have not supplied. Then supplying of inquiry report in compliance with the direction of the Howrah at the time of hearing at the time of hearing by the appellate authority. At 2 p.m. undersigned is hereby provided you a set of copy of inquiry report in connection with so and so. After that termination order remains, I'm asking one question to myself. It itself says violation of natural justice at the time of taking decision of termination. Just one paragraph I shall read, my lord, paragraph 15, page 9.
Page?
Paragraph 15, page 9 of my writ petition. It is enough to quash the order of termination. Paragraph 15. Page 9 of my writ petition. One paragraph.
During the course of hearing.
That's extremely helpful to my learned friend. Your petition states that during the course of hearing on so as per direction of the Deputy Director of Rationing Howrah, the first appellate authority, the rationing officer would handed over supplied a copy of the inquiry report in connection with termination. On receiving such report during the course of hearing, your petitioner requested the first appellate authority for fixing another date for hearing so that your petitioner make themselves ready to deal with such report. However, such prayer has been turned down by the appellate authority. Specific amendment. I have not been provided any time to deal with the report. Even I am not going to that far. By way of supplying inquiry report, they have accepted it is required to be handed over under the principle of natural justice, which has not been done before passing of the termination order. Termination order goes, first appellate authority, second appellate authority, all goes. Kindly take up the order passed by the first appellate authority. At click by
28.
78.
78.
Fine. No reason again. 78 is the communication. No, still not 78. Sorry. 103.
Orders.
Super passage. Well, kindly see. You'll also kindly go through it. Find what is the reason. Facts have been stated first, second, third, fourth paragraph. Then fifth paragraph. On 31st May 2023, the appellant admitted that he has received the copies of documents as sought for. In spite of receiving all the documents in the inspection report and in his complaints also, The applicant in his written submission letter also did not mention anything against the charge water I shall show. The offense committed by on the date of hearing, documents have been supplied to me. According to them, I have to give answer by written submission on the date. The offense committed by the appellant appears to have grave in nature, taking into consideration the fact that I do not find any one line order, 12 pages reply, appeal, not satisfactory. Termination, no reason, cryptic, unreason, non-speaking, first appeal on the date of hearing, inquiry report, principle of natural justice, termination, upheld without any reason. At least the first appellate should have considered that I have not prejudiced by virtue of not supplying the report at the initial stage of hearing by the licensing authority. But he accepted this document is required to give defense to the incumbent concerned. Just your lordship, kindly take note of this. I am not going to the second appellate authority order. Same thing. By way of supplying inquiry report on the date of hearing by the first appellate authority, says this report should have been handed over to me before passing the order of termination. By their conduct, they have admitted principle of natural justice has been violated at the time of termination order. These are my submissions. I am not going to the second appellate. Take note of the order dated 3rd December 2022. Today is not possible. Not time.
They have completed.
They have completed. ठीक है, I will complete my submissions. I have very limited scope. He has taken a point of natural justice. I will be submitting only with respect to that.
Second half.
Second half, not today, Your Lordship.
Not
Maybe on Tuesday. Because 16th, I have a few matters fixed. Otherwise, I would have done it on Monday. I will come back with specific. Oh, next week after.
Then after vacation.
After vacation.
It will be there. No issue.
And in the meantime, not to declare any vacancy. I have at least made out a case. Let him
finish, then it has to be hard by the
after
state.
Vacation, it is take after vacation. That's very specific where no vacancy has been notified.
Lordship.
Then on 23rd, I can fix it.
23rd. I will be fine with 23rd.
23rd?
Ah, yes, I will.
Fix the matter at a particular time.
Yes.
I will be fine with it.
Please take note.
23rd, I have.
आपने देखे
Matter appears under the heading of motion. Argument on behalf of the petitioner heard. The state to reply, state to argue on the point of interim order. Let the matter appear in the list on 23rd. At 12.
I have relayed a judgment. So for the reason is the heart of petition. I am giving the details of my learned friend so that he can make a representative. And I can hand over the copies also just now.
23rd December 12.
12.
So judgment I am handing over to my learned so that she can make yourself ready.
Okay.
ठीक है, ठीक है, ठीक है, okay.
The lawsuit is not be available next week. The interim order is expiring 23rd and that is what we are for. The matter may not be taken up before vacation. The interim order may be extended.
So let it be fixed on 23rd. 23rd. On that date, I will extend the order.
Some time may be given so that I can inform the other side. Anything subject to a lawsuit context.
On mentioning item number 34. On mentioning this matter be listed on 23rd at 11 a.m. under the heading of let the matter appear in the list on 23rd of December 2024 under the heading of mention matters.
and get much of it.
Okay. Grateful, Your
At
Lordship.
11.
Okay.
March.
You know, it's instruction.
My lord,
My
a
lord,
short indulgence, my lord, with regard to item number 8. My lord, it has, in the earlier occasion, Mr. Banerjee was coming up in reply. Item number 8 of today's list, my lord.
Yes.
My lord, I'm being led by Mr. Banerjee in this matter, Audit Banerjee. It's on his legs, my lord, he won't be able to the matter today. My lord, may be pleased.
Tomorrow or yesterday it was called. Yesterday
Yesterday it was called.
Yesterday it was called.
Yesterday we were.
It was running in the list. No one is appearing, so I passed it over.
My lord, may be pleased to fix it in some day in January, my lord. Because on his request, my lord.
Item number 8.
My lord, Mr. Banerjee has requested that we be fixed on
matter
13th
of
January.
it has already been delayed, my lord,
This
substantially.
is a matter of the petrol pump.
No, my
of
lord.
North Bengal.
No, North Bengal, it is LPG, my lord.
LPG.
Where vacancy was declared.
Okay.
While the original was.
Went up to Supreme Court,
My
thereafter
lord.
back.
My
Okay,
lord.
I understand. Whether estoppel is there or not, like it.
My lord.
Okay.
Mr. Banerjee was requesting for
January 8th.
My lord, kindly marks it heard in part, my lord. Because
See,
my lord has,
part
no,
matter?
I don't find, my lord, there is
My lord, it's
endorsement
not
here.
written in the list, my lord. The part had team, my lord. My lord, may be pleased to please fix it on January 13th because it will be
Next week.
January 13th.
January 13th. Okay, January 13th.
I am obliged, my lord.
January 13th.
My lord, may I have my lord's leave to mention, my lord, I understand, my lord, in the first half before rising, my lord, item number 34 was mentioned. My lord, no notice was served upon me while this matter was mentioned. It is appearing fairly at top, my lord, as per my lord's previous direction on 28th November, my lord. If my lord kindly sees the order, it was mentioned, and I think, my lord, it was rescheduled to 23rd. It had to Devan.
Some difficulties there.
My lord, I am suffering an interim order. This matter was fixed upon, my lord, in presence of the parties. Kindly seize my lord's order. It was fixed fairly on top. I don't know, my lord. They said that there was no notice served upon me. They got it rescheduled. My lord, let it
They have not
remain.
informed you?
No.
It is the listed matter. They must have
My lord,
informed you.
absolutely, my lord. Should have been on notice, my lord.
How can it be done?
Well, let it retain its position. Let them come and say if they have some difficulty.
Mention matter. Short matter they are saying ki bolne je short matter. For extension of interim order like that, they have.
But they are only interested in extending the interim order, my lord. They are not interested in hearing because it was fixed on 28th November. Kindly seize, my lord. On that day also, it was rescheduled. The hearing was rescheduled to my lord, today. So it was appearing fairly at top, my lord, as per my lord's previous direction, my lord.
Who is appearing for the appearance?
My lord, earlier, my lord, Mr. Sanal appeared. He did not mention. I'm sure, my lord.
Okay, Mr. Sanal did not mention.
Maybe the advocate record has appeared and mentioned it on a slide, my lord.
Advocate record খবর দিন বুঝানো অ্যাডভোকেট রেকর্ড অর্ডারটা করার আগে আমাকে বলবেন কালকে বলবেন হ্যাঁ এই অর্ডারটা আপলোড করলাম ঠিক আছে অ্যাডভোকেট রেকর্ডকে খবর দেবেন ওকে আই এম টেকিং নোট
my lord. तो कॉल होने
yes next call the matter
I understand, my lord, with the lordship's kind leave, my lord, I beg to appear on behalf of the college. Matter was heard at length.
Yes.
Submissions have been made, my lord, by all the other respondents, my lord. The university has also made its stand clear, my lord. So now, my lord, since, my lord, everyone has included the ingredients, my lord, for a palatable result, my lord, I'll just garnish it, my lord, with a few lines. Now, but what is this writ petition all about, my lord? My lord, we know, my lord, that relief under Article 226, my lord. I understand it is my turn to submit today. I will not take more than 5 minutes. Stay here.
I'll be just because code number 4 I'm going.
This will be taken up immediate. Your turn will come.
I'm not going to reply today.
Okay,
Oh.
I'm not going to.
okay. Then the reply has to be after vacation.
When senior Malad concludes, Malad, I'll be taking Malad 5 minutes time in replying.
Today, are you ready today?
Ask a code there here. I'll answer. I'll address your lordship for 5 minutes, my lord. He can reply it
No,
straight
he is
away.
not ready today for reply.
No, I am very well ready.
He is not ready. Reply is on his part.
Oh.
You don't know Malad, what excellent submission we are going to get.
No.
I'm going to take note and thereafter.
I'll just run through the facts, nothing more.
Okay, okay.
কি করবি ছুটির পরে করবি ভুলে যাবেন যশ সাহেব ছুটি যাবে আফটার ভেকেশন বলছেন যশ সাহেব এখন হবে না বলছেন দেখে নে
Submission later, our part we concluded. Then a complete reply by Mr. Ray.
Yes. This is what my.
Okay.
Very well. I'll not take more than 5 minutes, my lord.
Right.
What is this case about, my lord? We know, my lord, that relief under Article 226, my lord, of the Constitution of India, they are discretionary.
Yes.
And my lord, the law is, my lord, for the vigilant, not for the tardy and insolent. Here, what is the case? Here, the case is a person who had abandoned her service, which was again purely contractual in nature. Purely contractual, my lord, renewable from time to time. And that too, my lord, not, my lord, in perpetuity. Only for the, my lord, for those days, my lord, when Sanskrit classes were, my lord, imparted.
Yes.
There was no element of continuity also, my lord. So she, my lord, sought for, my lord, a leave, applied for it on the ground of maternity, not in its proper form. The governing body considered it with compassion. It was granted initially. Thereafter, it was renewed. Thereafter, she once again, my lord, submitted for maternity leave, my lord, which, my lord, out of pure compassion, my lord, was, my lord, granted ex post facto, my lord. There was a post facto approval, my lord, of the leave application because she applied for the leave application after remaining absent, my lord. So that was also granted.
Yes.
Now, the last of such leave, my lord, was submitted, my lord, pursuant to which, my lord, with a resolution dated 4th of February 2017, the childcare leave was granted without pay. Thereafter, my lord, kindly appreciates there is no communication, nothing. The college, my lord, seeing the conduct, my lord, because this was continuing since, my lord, quite some time. Now, they, my lord, adopted a resolution with their agenda, and the resolution dated 15th of July 2017, that we have resolved not to renew the contract. It's not a permanent post, my lord. Kindly appreciates, my lord. Purely,
Yes.
my lord, contractual, my lord. Renewable from time to time. Thereafter also, my lord, there was no communication. The petitioner chose to remain in deep slumber, my lord. Till, my lord, there was a change, my lord. Now, a memorandum was issued, my lord, by the Higher Education Department, Government of West Bengal. And the service conditions, my lord, those got restructured. Now, these contractual teachers, my lord, they were known as state-aided college teachers.
Sact 1, Sact 2.
Yes. Then suddenly, she being a fence sitter, she being extremely, my lord, indolent, not maintaining any communication, she knew very well that it has not been renewed. She thought of taking a calculated chance. And after 3 long years, suddenly, she knocks the doors of justice by way of filing the writ application.
Yes.
So this is nothing but to take a benefit. So a narration of events, my lord, as is reflected from the various averments contained in the writ petition itself will show, my lord, that the petition, on the basis of the averments made, my lord, does not warrant, my lord, exercise of high prerogative, my lord, discretion, my lord, under Article 226 of the Constitution of India. My lord knows, my lord, there is a concept known as abandonment of service, my lord. So even if we go by the sequence of events and if we see that post, my lord, 4th of February 2017, my lord, that was the last time when, my lord, the leave was granted. There was no communication made by the petitioner with the college authorities till, my lord, this 14th of March 2020. It is a clear case of abandonment of service. Judgment of 611 to SCC. Yes. But I'll, in this connection, my lord, rely upon, my lord, a decision of the Honorable Supreme Court of India, which is reported in 2006, volume 11, Supreme Court cases. Page 42, the relevant paragraph is, my lord, para 18, my lord. The conduct itself, my lord. Yes. Yes. But I'll just place from the place, my lord, just above placitum G. However, a bare perusal of the said purported notification dated 25/3/98 would clearly show that the Executive Council had in the said meeting been only considering the question of taking disciplinary action against the employees for having gone abroad without permission or without sanction leave, and those who have overstayed without prior approval of the university, although leaving the institution without prior permission of the Vice Chancellor, would fall within the purview of misconduct. Availing of leave undisputedly would be governed by the leave rules framed by the university. Proceeding on the leave without the same being sanctioned or overstaying the leave would undisputedly come within the terms of misconduct. Abandonment জায়গাটা কোথায়? কোনখানটা? কি judgment দেখাচ্ছে? But My lord, kindly takes page 44. I'm sorry, my lord. Page 44, my lord. Kindly takes only because the action on part of the employee to avail leave without any prior sanction thereof or to overstay despite expiry of the period of leave would amount to misconduct. Statutory authorities would not be denuded of power to make an appropriate statute that in certain situations the employee would be deemed to have abandoned his service. My lord. This is exactly the case here, my lord. And my lord, in so far as the case of legitimate expectation is concerned, my lord, first of all, my lord, he being a contractual employee, my lord, not working in perpetuity, and that apart, my lord, having not maintained any communication, my lord, with the university, being absent, my lord, for a prolonged period of time, my lord, the question of legitimate expectation, my lord, legitimate expectation is, my lord, an incidence of Article 14 of the Constitution of India. So Article 14, my lord, cannot confer any right on a person whose actions by itself are arbitrary, my lord. Here I will rather say, my lord, that the actions are absolutely arbitrary insofar as the petitioner is concerned. Had she been an Article 12 authority, there would have been a writ petition, my lord, which would have been maintainable against, my lord, the petitioner. 2006, volume 4, my lord, Uma Devi's case, the Supreme Court cases, page 1, para 47, my lord, states that, my lord, there cannot be any such right, my lord. So, my lord, these are my humble submissions, and my lord, I will not, my lord, judicial time is very valuable. My esteemed senior friend, my lord, Ms. Sengupta has already advanced her arguments, my lord. I will be also adopting it, my lord. It is a matter, my lord, which requires, my lord, no interference, my lord, under Article 226 of the Constitution of India. And the state, my lord, I understand, has also submitted their, my lord, written instructions, my lord.
Yes.
I'll be also relying upon that, my lord. There is no case which has been made out by the petitioner herein warranting judicial interdiction under Article 226 of the Constitution of India, my lord. This ought to be dismissed in limine, my lord. These are my humble submissions. Grateful. Kindly, my lord, here, Mr. Rai, my lord, I did not submit much, my lord, as I said. So petitioner can also give their reply, my lord. It will be fresh.
Petitioner, today not possible.
Takes it up tomorrow, my lord.
Kindly takes it up on the next week.
Why
Next week, this court is not sitting.
Tomorrow, my lord. Kindly keeps it tomorrow, my lord. It will be fresh in your lordship's mind also, my lord.
Tomorrow.
It's running from 2021.
If not tomorrow, then Not this year.
My lord, kindly takes it up tomorrow, my lord. Let it.
Tomorrow, Mr. Rai will not be present.
Virtually, he can do it, my lord. Now, technology has progressed a lot. But we conduct matters, my lord, while being out of station, my lord, virtually. Article 14 করো শেষ করো কালকে রাখতে বল মানে কাইন্ড টেক্সট এটা এই ওই তো বলে গেল কালকে রাখতে আজকে না রাখলে শুধু তো থাকবে না ভার্চুয়ালি করবে ছাড়ো তো দূর ঠিক পারবে তুমি ছাড়ো তুমি বাধা দিও না আচ্ছা লেট মিস্টার রায় কাম আপ এন্ড সে ইট মাই
Then come on 23rd.
23rd একদম
23rd
মানে 2 p.m. at that
23rd 2 p.m.
Great.
23rd 2 p.m.
Grateful to you.
Okay. Argument on behalf of the college authority concludes. Let the matter appear in the list on 23rd at 2 p.m. for argument on reply on behalf of the petition. Yes.
Grateful to you, Lordship.
My lord, item number 4, I'm for the respondent. My lord has heard Mr. Agarwal, my lord, on the last occasion, my lord, he concluded submission. Today, my lord, Mr. Agarwal requested me to do this matter next week because he has not come to court today. So, my lord fixes any date, my lord, I am ready with the matter.
What is this matter?
My lord, we'll recollect this is a matter where, my lord, the distributorship was terminated on the ground of reconstitution was not allowed, my lord.
Okay.
That mother died and
Okay,
other partners.
Okay, I understand.
Your Lordship, I'm on behalf of the petitioner, Your Lordship. I'm praying for not to delay.
That means after vacation.
After vacation. My lord is not sitting.
Not sitting in the next week.
Oh.
That is the difficulty. Otherwise.
My lord.
Okay. 6th of January.
6th.
The 6th of January. Yes.
This is, I will hand over a bunch of instructions. On the last occasion, on the 2nd of December 2024, we are still in 2024, Lordship was pleased to pass an order. It is on the 3rd page, Your Lordship. The pages are not numbered. I'm very sorry for that.
Yes.
The specific instruction was that there was a proposal on behalf of the learned senior advocate, Mr. Saha Roy. The second paragraph, Mr. Saha Roy, learned counsel for the petitioners, submits that the condition of the petitioners are precarious. They could not long time work their business without the bill being disbursed. He frankly submits that a specific order be passed so that 10% amount of each claim of bill of every month may be deducted towards recovery of alleged dues. Mr. Chatterjee, learned advocate appearing for the state authority, submits that he has to take necessary instruction. Considering the submission, the state respondents is directed to forward a specific instruction to the learned counsel for the state on the above mentioned proposal of the petitioners. However, as the petitioners are running their business, I think it necessary to pass an order. Let no coercive action be taken in respect of the business of the petitioners till further order. Let the matter appear in the list on 9 December 2024 at 2 p.m. under the heading to be mentioned. On the first page, Your Lordship, my instructions are there. This is to inform you that as per enclosed annexure 4, we have annexed the annexures also. The amount to be recovered from the bill of August 2024 and onward is rupees 43,80,927. The average amount of bill per month for their financial year 2023-24 was 39,68,23
per month.
Yes. And financial year 2024-25 was 55,187. Combining the total of 16 months bill commencing from April 22 to July 24. Average amount of bill for 16 months is rupees 42,39,14. As per Annexure 5, the proposed percentage of reduction is shown from 10%, that was Mr. Saha Roy's proposal, from 10% to 50%. If the proposed percentage of reduction is 10% per month, then it will be rupees 42,391 per month recovery amount. It will take 104 months for us to recover the amount. Deduction of 40% in the monthly bill will take 26 months at the rate of rupees 16 lakhs 95 6
No, 1 lakh 69.
yes, 1 lakh per month. Hence, it is proposed to deduct the amount of this per month rupees 2 lakhs, whatever, so that the recovery can be done within
50%.
Yes, 50%. This is my clear-cut instructions, Your Lordship.
Okay.
I am handing over a bunch of instructions to my learned friend
Okay.
so that they come over with necessary.
Short time.
Okay, you just read the instruction. Your proposal, upon your proposal, this court directs, and they have given the instruction. Please take down the written instruction submitted on behalf of the state authority is handed over through learned counsel Mrs. Sonal Sinha. Let the written instruction be taken on record. Full stop. A copy of the instruction be handed over to the learned counsel. Let the matter appear in the list with a specific reply of the petitioner whether they are agreeable to the instruction of the state authority. If they are agreed, the necessary order will be passed, and if not agreed, the matter will be heard on it. Let the matter appear in the list on January 6th.
Your Lordship, regarding January, because bill has not been submitted by the petitioner, Your Lordship. If Your Lordship kindly keep it after sometime 3:30 or 4 p. today.
You just read the instruction.
Read the instructions. Take instructions from your client.
Yes, take
Most
instruction, whether they are ready or not.
Before
Yes.
vacation, any date.
Before vacation, I have no time.
23rd, Your Lordship.
23rd, I have fixed several matters.
And one of the matters is
It's a matter, fixed matter.
No, this matter has to be disposed of.
Yes,
Okay,
my
all
lord.
the matters.
23rd, Your
I
Lordship,
intend to
at 2
dispose
PM.
of all the matters.
Your Lordship, on
2 p.m. I have fixed today another matter. That has to be disposed, long matter.
and that also on the 23rd.
Yes, 23rd.
3 p.m.
3 p.m. Because could not fix it.
On the last day, Your Lordship, I'm asking the question very honestly. On the last day, they will be here till 3 p.m.
Last day excessive burden of it.
Yes, exactly. Not only on you, but on us also.
Difficulty is this. For this reason, money has not been disbursed. And if he...
No, they are come with a specific proposal. I should say this is a very general and very generous approach of the state authority. They are ready to disburse your bill subject to some of reservation.
Then Your Lordship, petitioner will submit the bill as per direction of the Honorable Court.
Yes, I said first the direction. You just give me whether you are agreeable with the proposal.
Yes, then not to deduct in the meantime. If Your
Oh,
Lordship,
there is
in time. Everything is ready.
everything is ready. Everything is in place. Lordship's order is there. We have not done anything to you till now.
Already interim order is there. What is you are running the business?
Yes,
Everything is
specific the order. I have read it.
but bill has not been produced by...
Come on then, come on first day. First day of opening.
To 2nd of January.
2nd of January.
2nd of January.
I am fine.
Okay. Let the matter appear in the list on 2nd of January. Okay.
Grateful, Your Lordship.
Item number 6, my lord, Mr. Nirotpal Chatterjee is appearing for the state respondents, my lord. Last occasion, your lordship has passed an order that we have filed an report, my lord, and the petitioners were supposed to file their exception, my lord.
Exception.
And, yes, my lord. And they have sought for time as the advocate on record has expired. And, today, I suppose they are not appearing, my lord.
Let the matter appear in the list on 8th of January under the same heading.
Grateful, man.
Number 9 I am for the petitioner, my lord.
The application for restoration, can one is application for restoration application. But the item number person to item number 10, my lord. And item number 9, it was dismissed for default, my lord. But my lord, lordship was disposed on my lord, 16th of July 2024. Item number 9 and 10 are the both are the analogous matter, my lord. In item number 10, they have filed section 5 with the restoration application, my lord. Can 1 and can 2.
What is your name? Julius.
No, my lord. I am for the item number 9, Monaim Biswas.
What is the name of the petitioner? Item number 9.
Monaim Biswas, my lord.
Yes. Nimai Biswas.
Monaim Biswas.
Monaim.
Item number 9, my lord. I am appearing for only item number 9, my lord.
In this matter, my lord, I am for the state for item 10. Copy it.
Yes.
The copy has not been served upon us.
Have you not served the copy? The applications?
Last day, my lord, this was, my lord,
I have
my lord,
served the
apprised
copy.
to the court. My lord, they said, my lord, they'll serve the copy. But
Yes.
it was not served upon us.
Till today not
10.
served?
10. Julius Jaman.
No, my lord. Item number 9, I have served, my
9, my lord, I am not appearing.
You are not in 9?
No, I'm only in 10, my lord. That copy has not come to us. Expeditious hearing, sorry, my lord. Restoration and my lord, condemnation of delay.
You serve the copy which appearing in respondent number 9, private state respondent in this matter.
Dhar, my lord. Mr.
Have you
Super
served?
Senior. Yes, my lord. Before your lordship in front. End of December, my lord. I have
That is the
served in
affidavit
your
of service.
No, my lord. I have served in this courtroom, my lord, before your lordship, my lord.
Court, Mr. Dhar.
Yes, my lord. 2nd of December, my lord. So, my lord, I have served before your lordship, my lord.
Okay. So what is the matter about? I have told you on the earlier occasion, the order was passed on merit. Okay. If you had something in the merit, your matter can be restored.
Lordship was pleased to express that on the
Yes.
last occasion. my lord. Yes.
On the last occasion, because the order was passed on merit on the basis of the report of the state. That your application is not at the cited location.
But that that report is not handed over to us, my lord. Order was
Obviously,
passed.
you are not there. Obviously, you
Was
are not there.
submitted
That's why
for
the matter
before.
was disposed of. Order is very clear. Your application is not the specific location.
Meanwhile, of that time, my lord, Mr. Rabiul Islam is appearing.
I have directed you to take the instruction. You have to apprise this court regarding the merit of this matter, that you have something in the writ petition, so that I can.
As because we have not handed over the report, my lord, we cannot.
Report is not required. Order is very specific.
May
On the ground that
There, if we handed over the report, my lord, then we can file an
report is not
exception, my lord.
required. You just read the order. Order is very specific. Report received by the court from the state authority. Report said your application for the vacancy location is not within that location, your godown or showroom, like that. Proposed godown showroom. This is the only report of the state. There are 2 vacancy. One is masjid, near masjid, and one is near nothing. Normal Mauja is there. Name of Mauja, you have said. This is the only query. Gandra Beria. Gandra Beria. And one is Gandra Beria near masjid. These are the 2 locations side by side. You submitted the private respondent was allowed for the Gandra Beria. Authority said your application for getting license is in respect of another location. You cannot challenge the appointment of private respondent. This is the only report.
Yes. 2 separate vacancies were there.
Separate vacancy, side by side vacancy. One is Gandaberia, one is Gandaberia near masjid. These are the 2 vacancy locations.
The difficulties.
You take
My lord, both
instruction.
the matters are together. So, my lord,
Yes.
perhaps, my lord, let them, my lord, serve a copy, my lord, because this is a
You serve
question
a
of.
copy. You
Yes.
serve a copy to learned counsel appearing on behalf of the item number
10. I mean 10. 9, my lord, I am not.
also item number 10. Okay.
Can 1, my lord.
Can 1 and can 2 both.
We have only filed can 1 for restoration.
9, my lord, I do not know 9, but 10, my lord, there are 2 applications, I understand. One for condonation along with the restoration application.
We have filed the can 1 within the stipulated time period.
Can 1, can 2 both are there?
No, my lord.
10, you are not appearing. 10, he is not appearing, he's saying.
Item number 10.
Item number 10 is
Julius Jaman.
Julius Jaman.
And item number 9 is Monaim Recess, my lord.
Lord, may I, my lord, suggest, my lord?
Yes.
Let there be a direction to serve the copies upon us, and my lord keeps it any day, my lord, as your lordship pleases. So that, my lord, we can come prepared, and my lord, that matter can be disposed of.
Yes, my lord.
Let there be a direction, because otherwise, my lord, this will again come up, and lordship will not be
Yes.
able to assist your lordship.
only application for restoration in respect of Muniam Biswas.
Muniam Biswas, my lord.
Okay, please take down. Both the writ petitions are disposed of by a single order, by a common order dated 6th of July 2024. Full stop. Two applications for restorations were filed in respect of separate writ petitions. Learned counsel for the state appearing in item number 27 WPA 27305 of 2023 submits that the copy of application was not served upon him.
No, ठीक है.
No, it's okay. Full stop. As the matter, as the order of disposal has demonstrated some merit, so this court intends to hear the petitioner on the merit of this matter. Accordingly, the petitioner of WPA 201210009 of 2023 is directed to serve the application upon the learned counsel appearing for the state in WPA 273 of 05 2023 for effective hearing of this matter.
My lord,
Let the matter appear in the list on 8th of January.
my lord, may I, my lord, just point out, lordship recorded, my lord, 6th of July, perhaps. It is perhaps 16th of July.
16th of July.
And my lord, I am in 27305.
You are in 27305.
305 Julius Jaman.
Julius Jaman.
My learned friend is appearing in the other matter, 21009.
21009.
My lord, my lord.
তাই আছে তো নাম্বার গুলো দেখে নেবে
দুটোই ডিসমিস
8th of January তাই বললাম তো
আমাদের এটাতে অবজারভেশন ছিল অনেক কিছু মেরিটেও জজ সাহেব অর্ডার দিয়েছিলেন গ্রেটফুল টু ইওর লর্ড
yes
for the petitioner let me
No, this is the contempt application, Millard. I appear for the alleged contemptor.
yes
The state has preferred an appeal against the impugned order. Millard, the appeal is also running in the list of Justice Division Bench of Justice Mantha, fairly at the top as item number 26. But it's not.
okay let it be appear after vacation
My lord.
let it appear
But one thing, your lordship, by an order dated 26th of November 2024, your lordship was extend the interim order till 13th December 13. Your lordship kindly extend the interim order 13th December 2024. That is
okay interim order you want to enter
yes. Okay.
I will kindly note my kindly note my objection.
Yes.
Last occasion state did not
Because Millard, as on date, Millard,
objection. Did not raise any objection also.
very well learned counsel appearing on behalf of the alleged contender submits that the appeal is running in the list before the bench of honorable bench comprising honorable division bench of this court. Appeal is running in the list. Learned counsel appearing on behalf of the state authority submits that contemptor submits that appeal against the impugned order passed by this court is running in the list of honorable division bench for hearing. Full stop. Considering the submission, let the matter be adjourned today. List the matter on
1 week after vacation, Millard.
14th of January.
I'm grateful, Millard.
14th of January.
14th.
14th of January. First, next para. Land counsel appearing on behalf of the petitioner submits that the interim order is going to expire on 13th of December 2024. Let the interim order be extended. Now he prayed for, he prayed for extension of interim order.
Well, can you note my objection to that?
Landed counsel appearing on behalf of the state authority stroke alleged contemner raised strong objection.
Well, my lord, is recording no objection. My lord,
Very
can you-
strong objection.
I'm sorry, I'm sorry. Bilal.
Very strong
I'm sorry.
objection. Considering the submission of the parties, as there is no order of stay on the division bench, accordingly, I think it necessary to extend the interim order passed by this court on the earlier occasion. Next, accordingly, the interim order passed by this court on the earlier occasion is further extended till 17th of January or until further order, whichever is earlier.
We are grateful, my lord.
Before completion of the stipulated period, fixing,
It's my child. I may.
fixing. First, I will. First I will say about the maintainability of the petition. It is a contempt application, right?
May I beseech for filing an?
I will. 6 weeks. The matter was directed to be complied with.
We are on 7th week.
No.
Yes.
My lord, before 6 weeks, they have filed the contempt.
Lord, your lordship's direction was.
I'm showing.
Your lordship's
30th, the order was communicated. 30th, the order was communicated, and they filed the writ petition, contempt application on 6th of December. In any manner, I will, your lordship, I have got the brief. Your lordship direction, give me some time. I will get it compliant and come. This is the first time I have got the application.
Before completion of the period, they have filed the.
They have filed
the. This is your objection. Yes.
That is the first prime. I will get it done.
That come on 23rd.
23rd December.
Yes.
23rd December. But within 23rd December, it cannot be complied with because some time should be taken.
You start the work.
I will start.
Okay,
I will. As fairly from your lordship, I will start and come.
Start the work and report that work has been started. Okay.
Otherwise, if your lordship could see that 2 weeks after vacation, I will come with the compliance report again.
No, you start the.
My lord. But this should be written in the records that they filed the contempt application.
I am taking your submission. Learned counsel for the alleged contemner submits that the instant contempt application was filed beyond the period and within the period.
Prior to the period of completion.
Okay, prior to the period of completion.
Stipulated time fixed by this honorable.
Stipulated time fixed for completion of the work.
I can show you. It is from your lordship's order itself.
Considering the submission, let the matter be adjourned today. List the matter on 23rd. Under the same heading.
Grateful, man.
Well, then I need not to serve again upon the alleged contempt.
No.
My friend is appearing. Lord.
Yes.
The fact is this, they could have served because.
I have already served yesterday.
Then served, then what?
No, they have served me. But contempt.
Upon this contemptor also.
But then no. That is a formal service they should get.
Yes.
I was beseeching that no need to sign.
No need. No need.
Not necessary. He's appearing. What is it?
State in the earlier occasion did not appear. Also today did not appear. No
What is the matter?
No report has yet been filed. Matter relates to during the subsistence of the first vacancy notice, issued another vacancy notice. I have challenged the second vacancy notice as well as the first vacancy notice. I have participated in the second.
You have participated in the selection process in the first vacancy notice.
First vacancy notice.
So what is the fate?
No conclusion has been made. I have moved before this honorable court. Honorable court directed to conclude the selection process within certain time, if not concluded. But without conclusion of the said selection process, again issued a vacancy notice. I have challenged the same and prayed for interim order not to take any steps in terms of the second vacancy notice. My lord, after hearing, directed the state advocate to furnish a report. But till to date, no report has yet been filed. Several times took time for filing report, but nothing has been done. So I am praying, Lord, at least pass an interim order not to complete the selection process without leave of the court. First vacancy notice, page 13. Then petitioner's application, page 16. Then notice of inquiry, page 18. And then copy of the order of the Honorable High Court. That is page 20. And last vacancy notice, page 24. On 7th June 2024. An order of this Honorable High Court, that is on 30th January 2024 at page 20.
No, vacancy is deferred, I think.
No. Self-assembly. Central location.
Yes, central location has been changed.
Central location has been changed, but Mauja place, everything is same.
So it is a separate cause of action, sir. Like location has been changed.
In the earlier vacancy notice, no central location.
No, their central location means the Jagatpur.
Yes.
Jagatpur is the only location. That is the central location. But they have now said the Jagatpur central location, Bank of Baroda,
Jagatpur. That is also Jagatpur. Within Jagatpur. The same area, two vacancies.
That is why I am asking for the report. No report is filed.
On 5th 11, 2024 appeared and took time for filing it. But no report has been filed. More than 1 month. In the meantime, if any appointment is made, that my application is
No. So early. It is not possible.
Again, selected candidate to made him party, amend the petition. Problem will arise. All right, process may continue, but not to take any decision or final steps, not to issue license.
You come on 23rd. Please take down. State respondent was not represented. Full stop. In this matter, it was directed by this court to submit a report state respondent 6 accommodation. Since then, no report has been placed. Petitioner seeks an interim order. Having heard the learned counsel for the petitioner, considering the matter that the petitioner has challenged a vacancy notification dated 7th of June 2024 under the 24 issued by the SCFS concern for MR dealership license at the central location Jagatpur, within bracket Bank of Baroda, Jagatpur. It is the case of the petitioner that On the earlier occasion, no, earlier to the said notification, another notification was published on 17th of February 2022 in respect of same location, Jagatpur. Full stop. The petitioner applied for the said vacancy. Full stop. The authority concerned without completing the said procedure, vacancy procedure, has issued the instant vacancy notification dated 6th of June 2024. Having heard the learned counsel for the parties, this court has directed the authority state respondent to submit the report whether both the notifications were vacancy notices were issued in respect of the same location. However, no report has been placed. Accordingly, the matter be adjourned today. Release the matter on 23rd for submission of report on behalf of the state and for passing further order.
That's the same.
Under the same. Next.
Lordship 17 Lordship by FTA for the petitioner.
Who is appearing?
Lordship. But I'm trying to. I'm unable to switch on my video. Lordship, am I visible now, Lord?
FIR is appearing on behalf of the respondent number 6, Your Honor, private respondent. Honor, due to death in the family, he had to leave the court. It can be taken up any day, maybe tomorrow. He was in the court only. At 1 o'clock, he had to leave because there was a death in the family. Respondent number 6, the private respondent.
Chandan Goswami.
15 হচ্ছে দীপনারায়ণ, চন্দন গোস্বামী হচ্ছে 17। কোনটা হলো না? Mr. Bandyopadhyay and Mr. Ganguly is for the state.
Yes, ma'am. They were supposed to file, my lord. The state was supposed to file report in the form of affidavit, my lord. That has not yet been served, my lord.
Then come on 24th, not earlier than that. 24th.
The lordship will kindly pass an order, my lord, giving direction upon the state. Otherwise, the state will not file their report again because there is no direction. A small order, my lord. Obliged, my lord, obliged.
An accommodation is sought for on behalf of the private respondent on personal grounds. On personal ground of learned counsel. Yes, what about the report?
That's it, man. Will it kindly gives me 1 week's time, madam? The report is ready, madam. We shall affirm it and sign it.
Okay. Learned counsel appearing on behalf of the state authority submits that the report is ready, but it would be affirmed within a week. Considering the submission on behalf of the state respondent, the matter be adjourned today. List the matter on 24th.
My lord, they need only 1 week's time, my lord, as per them. So, my lord, that, my lord, ends on 18th.
Yes.
18th. So, lordship, my lord, in the meantime, if they serve us on 18th, my lord, I will file, my lord, my exception to the report.
I shall serve, my lord. I shall serve.
Yes, my lord, I shall serve, and 24th, lordship can dispose of the matter.
Man.
Else, my lord, they.
Agad line to Urgent today, list the matter on 24th. Thank you. Next part of the Korun. State respondent is directed to serve an advance copy to the learned counsel for the petition.
An exception, if any, in the meantime, my lord.
You just receive the copy, thereafter I will.
I understand, my lord.
We cannot.
Lord, item number 19, I appear on behalf of the petitioner. I'm led by
Item number?
19, my lord. Led by Mr. Hoyan Banerjee, my lord. This is my affidavit of service. The state respondents have all been served. The private respondent endorsement is he's absent. Lordship will kindly take up my affidavit of service I've indicated in the track report. I've tried serving on him, but the last endorsement is not delivered, addressee absent. With that, Lordship, and your Lordship had directed me to file the affidavit of service. May I place my case, my lord?
Yes.
Lordship. The petitioner had participated in 2022. A vacancy for FPS dealership was announced in the area where the petitioner is residing. The petitioner is belongs to SC community and also a unmarried lady. Now, Lordship, after all the recruitment processes, I was not given any dealership. I made a representation asking as to why I was not given the dealership. They did not respond. I filed a writ petition. Writ petition was disposed by your Lordship, directing the state respondent to consider my representation and pass a reasoned order. Challenging that reasoned order, Lordship, I have come before my Lord in this particular writ petition. My main prayer, Lordship, is that there is a notification by which scores are determined for the applicants who have fulfilled the criteria to obtain an FPS dealership. As per the notification of 2022, the person who has been given the dealership, who is the respondent number 9 here in the private respondent, his score as per me is coming to much lower than the score that could have been given to me. Kindly comes to page number 33, Lordship, once of my writ petition. 33. This is the score chart that I have prepared, taking instruction from my client. If the notification for scoring is followed, and if I compare the marks that could have been obtained by me, the petitioner, and the respondent number 6, I should be getting 67, and the private respondent who has been selected should be getting 65. After that, another notification.
This is your own chart.
Own chart, Lordship. The reason I'm giving this is because I'm trying to establish here is that I should have been given more scores. Now, Lordship, pursuant to the previous order passed in the previous writ petition, if your Lordship takes up their reasoned order, which is at page number 28 of my application.
Where is the reasoned order?
The reasoned order is page 28 of my writ petition. Has not been transparent as to what kind of scoring method they have applied to give me the score as well as score the private respondent. So it is not clear as to how scoring has been done. My only prayer as of now, interim prayer, would be let the state respondent file an report stating as to how they have given the scores to me as well as to the private respondent. And also, Lordship, if I may indicate one thing, one discrepancy in this particular the reasoned order.
What about your claim regarding additional marks?
Additional mark, they have refused, Lordship. Kindly takes up 2 points, may I just indicate? Kindly takes up page 28, point number 2.
Yes, read out.
Third line from the bottom. In this instance, although your credentials match the required criteria, your overall score is lower than that of Mr. Prosenjit Sarkar. But they have not substantiated it as to how or why the score is lower. Now, Lordship kindly takes up. Here they have stated that I have fulfilled all the criteria. Kindly takes up the next page, Lordship, in 29. They have written, during inspection of your godown, it was observed that facility does not meet the size and specification. On one hand, they are saying I have fulfilled the criteria. On the other hand, they are saying that the size and specification is not matching. They themselves are contradicting their own findings in their reasoned order, which is perverse in itself. And also, Lordship, I'm praying that a report may be filed showing as to how scores have been given. That is all.
First, for my lord, we are not statement respondents are not bound to give the exact what are the scores and all. I am carrying the same mind. Today, this matter can be disposed with these findings itself.
Okay.
First, my lord, first and foremost thing, my lord, I'm carrying the my lord report, and
It may be given to me.
Now, the difficulty is without giving the report, if I dispose of this matter, they will appear before the division bench and will say, without giving us the report, the matter was disposed of.
My lord, kindly, my lord, now I'm placing the my kind of matter. Kindly. So now, my lord, things are very transparent, my lord. My lord, first thing is that they have 3 points of repetition. I'm coming to it. Why the private respondent has been given the appointment?
Yes.
My lord, that particular issue has been settled by this
Honorable Court in this matter, my lord. This matter, my lord. Nur Islam Dolbaki, man. This settled issue, but the civic volunteer does not, there is no question of why he can't give, there is, that issue has been. And second of all, my lord, they have proceeded with the wrong notification. They have actually annexed the wrong notification, my lord. I will provide your lordship with the right notification as per the markings and all. My lord, this is the notification.
Lordship, one submission, let it be filed in the form of a report. If required, we file an exception to it, because handing over papers, then let them. It is not a frivolous litigation. There's obviously merit in my matter. Let them give me a copy of the
Yes,
report.
17th August 2021.
My lord, this is the notification that they should have been relied. And as per that, we have actually given our markings and all, my lord.
Let them disclose it then in a report. No, I will take an exception.
This is not required to be disclosed. Okay, this is not required to be disclosed.
The
This is the law
notifications
they
that
have
my
to
learned
follow.
friend is relying on, at least a copy may be given to
We have
me.
followed the law, and accordingly, we have in due process, we have rejected their application.
She doesn't have
And your specification of
my lord, they doesn't have that required go down sale counter, my lord.
your sales counter is 53.08 square feet. It is their report. Go down area is 550 square feet. But the sales counter is 53.08 square feet.
We will get a copy of the report, because our specific allegation is that not the point system which they have adopted.
My lord, this is not my. I have not.
I'm just asking for a copy of the report, not because they have to show that the point wise calculation is 4 marks of the private respondent. If they have made the calculation, the copy
Well,
is
I am
not
handing over the vacancy, my lord, vacancy notification. Kindly, my lord, I may be excuse, my lord. This mark
400 and 200.
400 and 200, 53 square feet, my lord.
Yes. You have no locus now.
I have participated. So not
Yes, you may have participated, but you have not selected the.
I'm saying that as per the marking system, my marks would be more than their marks. So they have to not show that what is the criteria they have adopted for calculating the marks, because I have made specific amendments. They have to show that that is incorrect. Now, kindly
That I have, my lord, already satisfied, my lord. They have proceeded on the basis of a wrong notification.
Copy is supplied to me, how they can
Wrong notification, my lord. But that, my lord, I am not bound to, my lord, since I am placing this to your lordship, my lord.
If something is relied upon, not the custom is that they will hand over a copy to the diagram.
Vacancy notification contains that particular notification through which that particular thing will be done.
Yeah, I get a copy, not so that I cannot take instruction and come back.
Yes,
Because they have
you serve a copy at least.
Only one thing, my lord. Only one thing. There is nothing of instructions, my lord. What, my lord, I have given hand over all the copies to your lordship. Then, my lord, again I have to come by way of a report, my lord. Then I have to file it by way of a report, my lord.
Okay, then you come with the report. That would be better. Okay, please take down the Didi. Having heard the learned counsel for the parties, it appears to me that the instant date petition cannot be disposed of without giving the state respondent an opportunity to file a detailed report. Let the report be filed within 2 weeks after vacation.
That side of vacation, my lord.
After 2 weeks.
2 weeks,
after 2 weeks of the vacation, exception, if any, against the report within 1 week. Thereafter, let the matter appear in the list on 29th of January. Affidavit of service filed on behalf of the petitioner is taken on record.
Number 20.
No, I am for the respondents. I am filing affidavit of service. My lord had already heard one matter on 9th. These two matters were there. So, my lord, your lordships has given me liberty to file a supplementary affidavit and came back to your lordships after vacancy. So, same order may be passed because this is same issues. Or else your lordships can decide the issue, my lord.
What is the matter about?
Matter, my lord, your lordships, my lord, kindly come to straightway page 37. I am a MR deal distributor. I have distributed the rations articles, and as per request, my lord, when flood area was there to meet.
Okay, okay. You have handed over some
Yes,
30 metric tons of
30
rice to
metric
the
ton rice,
flood
overcome the,
affected
my lord, the
areas.
critical situation. Now, my lord, time without numbers, I have repeatedly, my lord, made representation one after another series of representation, and that is an admitted position also, page 37. My lord, that has not yet returned.
So what you want to annex with this?
Well, some others, my lord, documents are there. I have given certain bad rice was exchanged, and I have given some more rice after that, 2018. My lord, that documents inadvertently was not annexed with this petition.
No. 30 metric ton of rice was given to the flood affected areas according to the instruction of the authority.
That is, my lord, that is in the writ petition.
That is in the writ petition.
petition.
So what new?
New means, my lord, some other documents are there.
They would not be in the writ petition. They would not the subject matter of the writ petition.
No. Subject matter
Whether
of
there is any connection with this writ petition?
Yes.
In those
Petitioner.
documents.
In the writ petitioner.
What is the connection?
Connection is, my lord, in the year 2018, same as per their instructions, I have, my lord, changed some bad rice that is near about, my lord, 1,000 quintals.
That is the separate.
Yes, that can be. I came up, your lordship, with a separate writ petition. That's not a petition.
Separate writ petition. So
that I can. Now your lordships can decide this issue. That I can come to your lordship on a separate writ petition.
On that writ petition, you are saying that is the connection is there. The matter has to be decided clearly. Otherwise, they can return it back like that. That's why I am allowed you to file the supplementary.
Two matters: SP Kundu and brothers, and my lord the Shaktipada Kundu. Two matters. Both the brothers, both of them are the MR distributors. My lord, this was one cause of action in the year 2015. Now 2017-18 also the same thing was happened. As per their request, I have given certain rice. I have changed some bad rice. That documents, my lord, I think I can come up to your lordship with a separate writ petition.
Yes, that will be better.
Yes, that can be.
That will be better. Otherwise, I can dispose of this writ petition today itself.
Your lordship can. Well, this is an admitted position. So let there be a direction upon the district controller to return at least this 30 metric ton rice, so that I can, my lord. On the contrary, my lord, what has happened? I have given 30 metric tons rice. They have inspected my godown and, my lord, imposed penalty 9 lakhs and 7 lakhs for mismatch the, my lord, the stock. Well, certainly, since I have given, I have not, my lord.
What happened there? You have paid the
yes.
fine.
I'm compelled because I am the
Whether you have challenged this matter in this writ petition?
That was there.
Whether you have challenged the penalty here?
Yes.
No, I think not challenge.
Yes. My prayer is also there. Your lordships kindly. Prayer A.
Penalty of 17 lakh.
Yes. That was also 30 metric tons rice,
Okay, this is
including penalty.
This is the first prayer.
This is the first prayer, writ petition.
So it cannot be disposed of.
And avertment is also there.
So it
and document is also there.
It cannot be disposed of. It has to be taken report. Otherwise, it is not possible.
This is an admitted position, page 37. Your lordships kindly come to page 37. This is an admitted position, subdivisional controller, food and supply, right to the letter to the district controller. Yes, this was happened.
What is your representation?
Representation, my lord, 30 metric ton rice should be returned to me.
That is the only your representation, not about the money or anything.
Yes. That is also there.
No, you read the representation, page 38.
No, page 38 for my lord rice, 30 metric ton rice.
Yes.
That is below page 38.
No prayer about the.
Well, I just 1 minute, your lordships, kindly give me. So far, my lord, the monetary is concerned. Penalty is there. That was I have, my lord, stated in my paragraph is there. My lord, abutment is there.
But you have not written in the representation.
That representation was perhaps, my lord.
Have you preferred any appeal against the order? You have already complied the order. Have you paid it? 17 lakh.
My lord, paid I am under compelling circumstances. On protest I have paid. On protest because I have no option. I will have to. I am the
Whether you have preferred any appeal?
My lord, your lordships kindly see the pay, my lord, TR Chalan page 33. I
understand you have paid.
I have paid.
But you have not challenged the matter in this writ petition.
Yes, that was prayer is there. Yes.
Prayer is there, but your
And abutment is also there. Then what else I can? I have challenged. Abutment is there.
So your writ petition cannot be disposed of on the basis of the representation.
That
If
can,
you want, I can proceed.
Yes, that your lordship, because I have, your lord, stated. What else I can? I have abutment is there, prayer is there. Penalty with 30 metric ton rise of return. That is all is there. And my lord, I have deposited money that challenge. Your lordships kindly come to paragraph, my lord, 15, 14. That was there. Lordship kindly come to paragraph 14, 15. Your petitioner state the respondent district controller after hearing the petition and impose a penalty to the extent of rupees 8 lakhs. And penalty was deposited the petitioner on Atho through TR Chalan. And next paragraph, my lord, 9 lakhs. Paragraph 19 also. But I am the distributor. So under compelling circumstances, I will have to deposit. Otherwise, my business will stop by them. The paragraph 25 also. My lord, the petitioner submit that the respondent district controller asked the petitioner to show, and the petitioner duly replied, and the said authority being not dissatisfied with the reply and imposed penalty tune of rupees 17 lakhs. That was there. Abutment is there, prayer is there. And it is an admitted position, 30 metric ton is. They will have to return. That is an admitted position. My lord, kindly come to page 35. My lord, representation is also there. So far penalty is concerned. Page 35. Nine lakhs.
What is your prayer? You read out the prayer.
Issue a writ of mandamus commanding the respondents to refund stock replace 30 metric ton rice supplied by the petitioner to the respondents Panchayat Samiti in emergency situation arising out of flood in the year 2015, together with Milot change of 1,920.67 quintal of inferior rice, which I have told your lordships. That was Milot, the bad rice was given by the main district government. That was Milot on instruction, that was changed by giving fresh rice from another source. Quintal and inferior rice for the purpose of maintaining smooth distribution of Milot flood food amongst flood affected people at Arambagh for filling up the deficit stock of rice for filing of deficit stock of rice of the petitioner without causing any further delay, and to refund the penalty of rupees 17 lakhs and to act in accordance. So my prayer was, Milot, include all. 30 metric ton rice should be refunded, and Milot 1,920 quintals rice, bad rice, which I have changed by replacing the fresh rice to the flood affected pupils.
No document is there regarding that prayer.
That document, my lord, I shall keep. That is the, my lord, list. That document, abutment is there, prayer is there.
And you also not made representation on that basis of that prayer.
Yes, yes, representation was there. That copy is with me. That was somehow, my lord, inadvertently. That's why I pray before the lordship, just so that I
Can
can.
you file a fresh writ petition? It will be better.
No, my lord, supplementary affidavit will suffice. Because you have already.
How far supplementary affidavit can.
Abutment is there, only documents. Abutment is there. Because earlier writ petition, your lordship has already gave me liberty to file a supplementary affidavit.
Then you file supplementary.
And my lord, so far the 19 lakhs is also representation is there at page 35. That is there. Page 35 for 9 lakhs penalty. মহাশয় আপনার অবগতির জন্য জানাই যে আমি শ্রী সুব্রত কুণ্ডু মেসা শক্তিপদ কুণ্ডু সাচ এন্ড সাচ একজন অংশীদার সাচ এন্ড সাচ অনুযায়ী দপ্তরে ধার্য
That is in respect of 9 lakh only.
9 lakhs. 9 lakhs is there. No, that I shown to your lordship that is representation was there. 9 lakhs was annexed and inadvertently another 8 lakhs was not annexed and these documents for rice. That is only 2 documents. So my bona fides below is there. I have, it's a fact that I have given and I have changed the rice also.
Okay, let's see how far you can estimate.
And below 30 metric ton rice is admitted. So everything is admitted.
Petitioner is lived to file supplementary affidavit in support of the writ petition. Let the matter appear in the list after 2 weeks of action.
After vacation, that matter was also there.
After 2 weeks of vacation.
Then Milord, the petition is also appeared along with Milord WPA number 28001, both same. This is analogous.
So when the date was fixed?
That is your lordship fixed after vacation.
After vacation.
After vacation.
Along with writ petition?
WPA
28001.
28001. 2014.
2024.
It is an admitted. 30 metric ton is admitted. Penalty also, my lord, I have given due to deficit of stock. Grateful to you.
21.
But kindly have a look, Major, page 71, annexure 12. This is the second time.
Have you served?
Yes, Lord, I have served everybody. I have served
Give me the affidavit of service.
But only, my lord, affidavit of service not affirmed actually.
Then you have to come with the affidavit of service. Not today.
Monday.
Not today.
22.
Give me the papers.
22, I received the notification of the advocate for the petitioner. He has said that he has specifically paid leave before your lordship today in this matter. Probably perhaps it's not available.
For the petitioner?
Yes, yes, your lordship. Not there.
Very well. Not today. কি স্যার দিলেন কেন মেনশন করেছিল তো কি
Not today.
ওকে পাঁচ it over. Oh, it was mentioned to be taken up today.
Yes, fine.
But now when that it was called, no one is there. This is irony. Yes. Next.
23. For the state, Minister Bond.
23, I am for the petition, Your Lordship. Your Lordship, there are few inadvertent mistakes in the petition, Your Lordship. So I want to withdraw the same and file afresh with the same cause of action, Your Lordship.
Please take down.
Self-same cause of action.
On the submission of the learned counsel appearing on behalf of the petitioner, the instant writ petition is disposed of as not pressed. The petitioner is at liberty to file another writ petition on the basis of self-same cause of action. Next.
24. 24.
For state.
None appears for the petitioner. Very well. You are for the state.
Yes.
Just wait. I am passing it over.
25, 25, I have submitted.
My lord, this is related to, my lord, creation of new vacancy in the area where the petitioner has been running his fair price. The lordship will be pleased to see paragraph 3. Page 3. And memo number 195, page 16. Page 16, annexure P4. Subdivision Kontai, log Ramnagar 2, number 3. Your lordship, right hand side, my lord. I am sorry, my lord. District copy could not be supplied to your lordship. From the notification itself, my lord, it has been xeroxed. Serial number 3. Right hand side from the top.
Why not giving a fresh copy? I cannot read it out.
My lord, this copy is, my lord, totally legible, maybe possibly legible. I am sorry, my lord.
So you have to make it scan and then file it.
My lord.
Why are you taking a Xerox like that? Same.
And my lord. Separate copy could not be. Page 14, my lord, license. Has been running such fair price shop within that area, including the other adjacent areas, including the, my lord, place of the new vacancy that is to be created there. And my lord had been pleased, my lord, to pass identical order, my lord, during pendency of the appeal before the division bench. Your lordship had been pleased to pass order directing the authority not to fill up the vacancy. Although all steps are to be taken for processing the application. Paragraph 7, my lord, units, my lord, enjoyed by the petitioner. 744.
What is the notification?
My lord, page 5.
Page annexure 6 P4. P4 16.
Paragraph 5. Page 4. Your lordship, I am sorry.
No, no. Come on, page 16.
My lord.
Page 16.
Page 16, my lord.
Which notification you have challenged?
Notification. Serial number 3. Ramnagar block 2. Serial number 3. 195 memo. Dated, my lord, 16th May 2024.
Serial number 3, Ramnagar 1.
Ramnagar 2. After Ramnagar 1. 195. CFS dated 16th May 2024.
Have you mentioned in the pleading this memo you are challenging?
Paragraph 12 also.
Paragraph 12.
Paragraph 12 also. Page, my lord, 8.
Okay, please take down. আপনি কি এগুলো নিয়েছেন? আইডেন্টিক্যাল যেগুলো অর্ডার করি and নিয়ে তাহলে নিতে হবে। নাহলে কপি আছে ওদের কাছে, বলে দিচ্ছি ছোট করে নিয়ে। হ্যাঁ, আলুর কাছে আছে, নিতে পারেন, বলে দিচ্ছি নিয়ে ছোট করে নিতে পারবে, কিছু করে দিচ্ছি। Affidavit of service filed on behalf of the petitioner is taken on record. Present petitioner is running FPS shop under dealership of concerned respondent authority at Mauja, Kanpur. Full stop. He has been allotted 7,440 units. 7,440 units for distribution of MR goods. Full stop. The petitioner challenged a new vacancy notification being memo number 195/CFS/2024 dated 16th of May 2020. Notified for issuance of new fair price shop in the same area wherein the present petitioner is running the business. Learned counsel for the petitioner submits that after promulgation of National Food Security Act 2013 and targeted public distribution within bracket control order 2013, WBPDS within bracket M and C order 2013, on the basis of which the impugned notification was published, has become redundant. Full stop. Next paragraph. He submits that the issue involved in the writ petition is also involved in the batch of appeals pending before the division bench, bearing MAT number 1543 of 2024. Full stop. He fled for an interim order. Full stop. Despite service, none appears on behalf of the state authority. Full stop. Next paragraph. Considering the submission of the learned counsel, state authority is directed to submit a report in support of an affidavit within 3 weeks of publication. Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Considering the fact, next paragraph, considering the fact and circumstances of this case and considering the issue involved in this matter, it appears to me that the challenge of control order 2013 has already been made before the Honorable Division Bench in MAT 1543 of 2024. The Honorable Division Bench has also issued an order, an interim order, directing the state authority not to delink any ration card from existing ration dealers. Considering the above mentioned situation, I think it necessary that petitioner deserves a similar order. Full stop. Hence, it is ordered that the state authority may proceed with the selection process, but so far as issuance of license is concerned, that shall not be commissioned in favor of any person till disposal of the batch of appeals pending before the Law and Division Bench, being MAT 1543 of 2020. Let the matter go out of the list. Parties are at liberty to mention.
Twenty-six.
My lord, I am for the state respondents.
Better, my lord, same block.
My lord,
That the memo
before my
is
learned
in-
friend submits, my lord, the copy, my lord, I
Yes.
can't even begin to read.
I am sorry,
My
my
lord,
lord, I
how
have
will I
the
assist you?
type copy to be supplied afterward.
Then you type the type copy. So, this is also painful for the court. You are submitting these copies. I could not read it out.
My lord, absolutely illegible. Kindly seize, my lord. The copy has been covered.
Why are you filing these copies like that? I cannot read it out.
My lord, I can.
You file it fresh. The documents at least.
My lord, the copy is to be, my lord, typed copy is to be supplied
Yes.
to the lordship.
Yes.
And next one also, my lord, same.
Then you file a type copy.
Yes.
Not today.
Grateful, my lord.
But next week, your lordship will take up the matter or tomorrow.
Not today. Tomorrow I have other determinations.
Yes, my lord, your lordship told not that. Yes. 27.
Next, same.
Yeah.
27, same.
Not today.
Okay, next.
Third.
28.
So we have not received the instruction yet, your lordship.
I had a talk with Ms. Sonal Sinha. I can start because it will take some time. Mr. Bandavada is also there. It will take some time.
Yes.
Yeah, the motion belongs to other backward class, made an application for appointment of fair price shop dealer pursuant to the vacancy notice dated 26th of August 2022. Will also kindly turn the page to 32. Then notification dated 26th of August 2022.
Yes.
The area has been defined, my lord. Sonnasi Tanga, Police Station, Naura, District, Murshidabad. Now kindly come to page 35. But this is the date indicative notice. Serial number 26. Kindly see, my lord. Murshidabad, Behrampur subdivision, Nauda, Bali 1, Moja Swanso, Sonnasi Tanga. I will also got my lord, serial number 26.
Yes.
And from this date, application shall be submitted within 21 days. First paragraph, last line, bottom.
What is the date?
21 days from this date. And both we have submitted our application within time. That is
Okay.
this. Now, your lordship, kindly come to page 30.
38.
The acknowledgement in respect of my
duly filled in online application submitted by the petitioner pursuant to the vacancy notice, 2nd of February 2023. Kindly see the date.
Yes.
Now, next page, my lord. The sketch map of my godown and shop room. You will have to kindly take middle portion shop counter 14.5 into 24.4. It comes 3.35, 3.85 square feet. Requirement is 200 square feet. My shop room is 353 and godown is concerned, my lord. 18.4 into 20.24.4. It comes, my lord. 448.96. Totaling, my lord, 802.81. 400 and 200 is required. Total.
Yes.
Your lordship knows, my lord. Then kindly turn the next page. A notice has been issued to my client for inspection to be held on 30th March 2023.
Yes.
But on that time, my lord, inquiry has not been conducted. A fresh notice has been issued, if your lordship kindly see. Ultimately, inquiry has been conducted on 13th of April 2023. That would appear from the inquiry report I have annexed, page 41. Kindly see, my lord. Name of the official, designation Inspector Himanshu Das and Anupam Datta, both are Inspector Food and Supplies. Date of inquiry, right hand side, 13th April 2023. Then serial number 9, name of the applicant, Sabina Jasmine. Now turn the page, my lord, next page. Serial number 20, whether the applicant has submitted bank details and you have verified. Yes. So bank details have been submitted, it has been verified. It was found that record money was in the bank account on the date of inquiry. Comment, serial number 20. The applicant is submitted all the documents as per checklist. Next page, my lord. Kindly turn to page 43. Serial number 50. Storage godown and office details need not go through the same. Sub number, everything has been given. Village Sonnashidanga within the central point of location. Then 51. Details of the shopcom godown proposed, whether godown is under construction. No, it is completely constructed. Dimension of the godown, which I have disclosed, my lord, 448. Character, this is the godown. Character of the premises, Vastu. Size of the sales counter has been given. 353, it's multiply. It comes 802, which I have disclosed in my application. Same. Then on the next page, top. Whether measurement instruction are caliber, yes. Whether the width of the approach door is sufficient for loading and unloading, yes. Whether the device is for encompassed, yes. Storage capacity of the godown, 400 metric ton. Building type, shop and godown located on the same floor. Whether layout plan has been tallied, yes. Then kindly turn serial number 56. Distance from the central point defined by landmark of the package area at meter. Kindly take note of this 65 meters. Then 57 is not applicable. It says comment on suitability. The shopcom godown of the applicant is tuned with the geo number so and so. The godown has proper ventilation facility and it is suitable for storage of food grains. The comments. The next page. Page 45, serial number 59 is top. Period of Chris tenancy under registered agreement. 28 years. Information level 12 years. Then serial number 62. Whether details of the godown forward with the appropriate documents? Yes. Whether the premises is under physical position of the applicant? Yes. Comment. The shopcom godown of the applicant fulfill all the criteria in respect of the documents and also the measurement of the godown is comply with geo number 12. Subject finding. Local reputation of the applicant good. Any document not submitted, all the documents are submitted. Overall comments with, it's very important, with positive, negative recommendation. The shopcom godown of the applicant is most suitable. Take note of most suitable. Not suitable, not more suitable, most suitable. Storage of godown, food grains, and distribution of food commodities. The applicant is submitted all the documents as per checklist. The application is placed with positive recommendation. Kindly take note of positive recommendation. and new license may be issued in favor of the applicant. Most possible recommendation license may be issued. This is the overall remarks in
Yes.
respect of the petition. Can you take note of? But who are given this certificate, my lord? The field inquiry officers. Who are the best person to adjudicate? Who are the best candidate? Statement of signature of the officials, both the inspector of food and supplies. Then next page. This is in respect of the private respondent. Serial number 9, name of the applicant, Imran Ali. Date of inquiry, top pilot, 30th July 2023. Top.
Yes.
Well, kindly once again come to the first page of my inquiry. This is very relevant. Page 41. Date of inquiry, 13th April 2023. Date of inquiry, so far the private respondent, 30th July.
Yes.
By specific case made out on the date of application, there was no constructed godown and showroom. This time has been provided to the private respondent for construction of godown. It is apparent. Inquiry should be done at least within 7 days. There is no first and third rule, but to give opportunity to all the persons to complete the construction, it should not be after 3 months. 30th July means, my lord, more than 3.5 months, more than 100 days. This has been provided to the private respondent very intentionally to complete his construction.
Yes.
Now kindly come once again, page 41, who has conducted inquiry so far my candidature is concerned, page 41. Name, Himanish Das and Anupam Shah, left hand side, top. Designation, inspector. Have you also got my lord? Page 41, left hand side, top. They are the inquiring personnel so far my candidature is concerned. Him designated as Inspector, Food and Supplies Department. Page 47, so far the private respondent is concerned, after 3 months, more than 3.5 months, Kanti Sarkar, Chief Inspector, left hand side.
Mrinal Kanti Sarkar.
Mrinal Kanti Sarkar. He is much above the inspector. His command is has to be taken note of by the inspector. So far my concern, I am concerned, only inspectors, higher rank officer, Chief Inspector conducted inquiry along with Himanish Das. Inspector and sub-inspector. 3 persons conducted. Chief Inspector, Inspector, sub-inspector. Almost separate team. Out of 2, 1 has been do not and other 2 has been. Kindly see there is no sub-inspector. So far I am concerned. Both are designated as inspector. So far this case is concerned, 1 inspector, 1 chief inspector has been hired. A fresh committee has been constituted. Not the same team. So far I am concerned, 2 inspector. So far my learned friend's client is concerned, 1 chief inspector, 1 sub-inspector who are not present during the course of inquiry conducted in my shop room. Now kindly see the serial number 9, name of the private respondent. Need not go through the page 48. Kindly turn to page 45. Dimension, serial number 51. Chamber, kindly see. It comes 7 to 9 total. 7 to 9 is the go down. 7 to 9 is the go down. If we multiply by 20.50 into 12.80, 7 to 9. And 260 of proof. If we add it, comes down 802.
With the leave of the learned friend, this license was issued in August 2023. Thereafter, a repetition was filed. The court directed for consideration of his representation by the district magistrate. Now, district magistrate gave notice, he considered he finally passed an order, rejecting his representation. This, there is no question of passing any interim order. But what I suggest that let us file the affidavit in opposition. This is not a case, my lord, at the stage of interim order or the selection.
I am suggesting your lordship to dispose of the matter.
It cannot be done, my lord. If the allegations,
the problem.
My lord, with the allegations which they are making, my lord, this is their brainchild. So I cannot, my lord, deal with it without filing my affidavit.
If there is a direction of the district magistrate,
of the district magistrate.
I have been called for to participate in the hearing on a particular day. I made a representation. I am admitted in hospital.
This is also false, my lord. I'll just show one page. Kindly take his representation.
My submission. What is this? Mr. Pandit, it is not expected from you. Not expected from you.
No, let him submit.
As you let him submit.
You wanted to submit, let him submit.
Because this cannot be.
Okay, let me finish this. Let him finish.
The difficulty is that when opening one after another page, he thought it fit not to allow me to continue a submission. That's the. Then your lordship kindly. 49.
Yes.
Total area 729.09 and 200. It comes color 802. I shall show to you. So far I am concerned 802.76. So far he is concerned 729.09. You should kindly take note of it. Total area go down and shop to private respondent 729.09. My client 802.76 from the report, not my disclosure.
So both are eligible in respect of the go down and shop down.
So far, your lordship knows 7,000 to 800.
Yes.
Above 40, 50. Your lordship
okay.
knows. 13, 15 and 17. Above 8,000, 800. I shall show to your lordship. Now, your lordship kindly turn the page my lord 51. Here number 67. That's the ground for not to allow me to make my submission. Here number 67, one of the ground. Overall comments with positive, negative recommendation. The shop farm go down of the applicant is shown with the geo number so and so. The applicant is financially solvent, fulfill all the criteria for FPS, the applicant may be recommended. So
Yes.
I am concerned, most suitable may be recommended, not maybe recommended for granting license. I have shown to your lordship.
Yes.
The ground level inquiring committee. So far, I am concerned, separate team. So far, Mr. Bandapataya client is concerned, 3 persons. May be recommended. The language of my application, once again, for my satisfaction, 46 people lordship kindly turn up. Applicant is most suitable for storage of food grains and distribution of PDS commodities. The applicant is submitted all the documents as per checklist. This application is based with positive recommendation and new license may be issued in favor of the applicant.
Yes.
Overall remarks. I have shown to your lordship the remarks. So far, my learned client is concerned may be recommended for paper review. Then your lordship kindly come to page 4. Next page. I lodge a complaint. So far, his focus shop farm go down is concerned at page 52. While I came to learn that despite fulfillment of all criteria and some specific recommendation by the respective personnel, they are going to give license to the private respondent. I want this complaint also kindly take me to go through the same. With due respect, I get to inform you that Sabina has been right of also. I have requested go down office stamp shop, check and other necessary relevant documents according to the criteria mentioned in notification for the date grade, and all documents are submitted during the inquiry go down which held on 12, in which both officers being satisfied but taken irrespective without notice on 30th July 2023. Second inquiry. Now, after the second inquiry, after applicant gave the internally, so are preparing a go down, like to be a go down, with marked with numbers of short height distance with remove partition is according to the residential room being converted into shop farm go down after conducting inquiry. That's my complaint on 10th August 2023. Then kindly come to the next page, same complaint. The pictures I have given, photographs, start from page 54. So far, this shop is concerned in the residential house. Page 54, 55, 56. Then the mass representation of the consumer at page 57, 29th of September 2023. It continues. Then kindly turn to page 60. A requisition was moved by my client, Sabina Yasmin, before Justice Vivek Chaudhary on 21st of September 2023. I am reading the order. Upon a vacancy need not go to the first paragraph, second paragraph. The learned advocate for the petitioner submits that after filing the application, both the petitioner and private respondent were informed that an inquiry will be held on 13th April 2023. The said inquiry was a court-based inquiry conducted by the respondent. It is contended on behalf of the petitioner that the petitioner had all requisite eligibility criteria, and the resident inspector was satisfied about the eligibility criteria of the petitioner. Subsequently, a second inquiry was made, validate notice, without giving any notice to the petitioner and the private respondent was selected for dealership of the transaction. It is further contended on behalf of the petitioner that in the first inquiry, the private respondent had no ground by specific allegation. The private respondent had only a vacant flat in front of his house. In order to give license to the private respondent, further inquiry was conducted on 30th July 2023, and the respondent was selected. It is submitted on behalf of the petitioner that second inquiry was illegal and arbitrary in view of the fact that the respondent number 9 was given an undue advantage privileged by the state court. Learned advocate for the private respondent 9 submit that the admittedly the inquiry was done on the basis of a court-based evaluation, and the petitioner obtained 59 marks during the inquiry, while the respondent number 9 got 64 marks, and therefore he was selected. License was also granted to him. There is no illegality, arbitrariness, or malafide in entire process, and the petitioner is harassing in the nature. Kindly take note of the private respondent disclosing without any report submitted on behalf of the state what marks he has obtained. Kindly take note of it. On that day, there was no report on behalf of the state, no disclosure. The first motion has been disposed of, as I understood from after going through the orders. He discloses before the court that I got 59 marks, private petitioner got 64 marks. Despite fact remains, inspecting personnel said, I have the most suitable content, my name should be recommended for grant of license. So far my learned friend client is concerned, his name may be recommended, Then my lord, sales counter, I have raised objection, page 62, last 3 lines of first paragraph. It is also submitted by the learned advocate respondent that the godown of respondent was completely inconstructive. I have considered the submission made by the learned advocate for the party. It is not in dispute that the petitioner was not with the notice that inquiry would be held in respect of a proposed shop from godown on Thursday. The said inquiry was held on 30th April 2023. Subsequently, the respondent godown and the shop room was inspected on 30th July 2023. Can you take note of? Admitted position. Though it is submitted by the learned advocate on behalf of the private respondent that 30th April the proposed godown and shop rooms of the application were respected, and 30th July the same was re-verified. It has been re-verified. Therefore, it is not the fact that the petitioner godown was not verified on 30th July. So, second inspection only in respect of the private respondent. 30th July. So, far my report is concerned, my lord, 13th April. With that as it may, when the petitioner submitted two petitions dated 10th August 2022 and 23rd August 2022 to the district magistrate Mustafa and Gaurav, questioning the eligibility criteria of the respondent number 9 on the date of inquiry, the said requisition ought to be considered by the authority. It is submitted by the learned advocate for the petitioner that the district magistrate is the chairman of the district level sub-selection committee. Therefore, the instant petition is disposed of directly the district magistrate Murshidabad to cause an inquiry either by the Murshidabad and dispose of the requisition submitted by the petitioner within 16 days from the date of publication of the order, after giving opportunity to petitioner and respondent line. But pausing for a moment, I have not appeared in this case. A district level sub-selection committee, I am not criticizing this order, has decided to select private respondent. headed by the district magistrate. Since the learned advocate for the petitioner is submitted, district magistrate can dispose of the matter. Matters that has been remitted back to the person who has already decided to select private respondent. I cannot, because I have not challenged this order. I have accepted this order. But fact remains. Now, Your Lordship, kindly see what happened thereafter. Kindly turn to matter page 65. The date of inquiry. 7th November 2023.
Yes.
Middle portion, first table, name of the applicant, Sabina Yasmin. I am concerned. Hard inquiry, in fact, my lord. So far the private respondent is concerned. Then 7th November 2023 report has been submitted. From description, then my lord, kindly state where after page 7.
What is this? This is further inquiry?
Yes.
Further
inquiry at the instance of the district magistrate.
district magistrate. After the order.
But I know the facts. I can satisfy the court the facts. At least I may not know the law. I know the fact at least. Kindly similar date of inquiry 7th November 2023.
Yes.
Time and again don't jump. Date of the time and inquiry 7th November 2023. That the instance of the district magistrate after passing order by the district. Now you have to kindly turn page 7. I made a legal representation. Kindly see the date of order passed by Justice Vivek Chaudhary and when this inquiry has been conducted. Justice Chaudhary passed the order far back on 21st of September 2023.
Yes.
Till February, end of February, no decision has been taken. The court's direction was to complete the process within 60 days. The appeal from 62A.
Yes.
From September 21st, 60 days expires November 21st. No steps taken. I have been compelled to give a legal notice on 26th February. Representation is kindly down to page 72. A notice has been issued in the month of September 2024. Take note of the date. Justice Chaudhary, inquiry, legal notes, then minor notice for hearing. 4 dates are very vital.
Yes.
The body of the letter says and inquiry should be conducted on 13th March 2024 at 12 p.m. Now kindly come to the next page. Has been issued on 7th March. I have received it on date. I have categorically stated in petition. The kindly down page 73. On 11th March, right hand side bottom, Sabina Yasmin, then the date 11th March, which has been received by the authority on 12th March, which will appear from left hand side bottom. আমার ডিলিটি নিবেদন এরিয়া আমি সামনে আসছি ওয়াইফ অফ আবুল কালাম আমার ডাব্লিউ এর নাম ক্যান্সার ম্যাটার আমি শারীরিক অসুস্থতার কারণে হাসপাতালের চিকিৎসিত অবস্থায় রয়েছি অ্যাডমিটেড ইন দ্য হসপিটাল অন 11 রিসিভ 12 গতকাল হয়েছে আমার চিকিৎসা চলছে গত 4/3/2024 তারিখে আমার রিমান্ড হয়েছে যে আগামী 13 তারিখে হিয়ারিং এর জন্য ডাকা হয় আমার শারীরিক অসুস্থতার কারণে আসতে পারছি না অতএব মহাশয়ের কাছে আমার ডেট চেঞ্জ করে পুনরায় আমাদের হিয়ারিং এ ডাকা হোক This has been written on 11/12 received 13 was get fixed for that. Next page. Medical document, Sabina Yasmin of the local hospital, government hospital. Then the reports of the medical, 11th March 2024, page 75. Department of Health and Family Welfare, Government of West Bengal Discharge, page 76. Sabina Yasmin, 11th March. Then, my lord, I came to learn after my recovery from the illness that hearing has been concluded, proceedings has been concluded in my absence. I wrote a letter again on 4th April 2024. আমার ডিটেইল ব্যাপারে যে আমি সামনে আমি আব্দুল কালাম মন্ডল নাম সংগঠনের বা জয়েন্ট ডেট দেওয়া গত 13 কিন্তু আমি আমার শারীরিক অসুবিধার কারণে হসপিটালে ভর্তি হয়ে 10 তারিখ থেকে 13 তারিখ 4টে পর্যন্ত। তাই উক্ত হেয়ারিং এ আমি শারীরিক অসুবিধার কারণে বুঝতে দিতে পারিনি। বর্তমানে আমি সুস্থ রয়েছি, তাই আমি মাননীয় বাসের কাছে আমার হেয়ারিং এর বিষয়টি দেখার জন্য সুযোগ আছে। অতএব এই বিষয়ের কাছে আমার ভাবতে পারতো না আমার উক্ত হেয়ারিং এর বিষয়টি পুনরায় যাতে হেয়ারিং এ রাখা হয় তার সুবর্ণতা কর্মকে রাইট।
Yes.
Then this is my lord before passing the order in bill. Kindly, you'll have to 1 second for my satisfaction. Kindly turn the page 76. Kindly see page 76 block legal portion date of discharge. Have you not got my lord?
13 March 2024, date of admission 11th March 2020.
6 for here. Time kindly see 4 p.m. Just right hand side.
Yes.
So I could not participate. Prior to that, I will give it. They have acknowledged that. Despite specific knowledge that I am unable to participate in the hearing due to my illness, I got admitted in the hospital. Subsequent communication, please call me for further hearing. That was so hurry. Hearing has been concluded on 13th March itself, but no order. After 2 months, kindly turn to page 78, 20th May 2024. Almost after 1 year from the date of passing order by Justice Chaudhary. The area inspector Department of Food and Supplies also with the request to serve the copy of the received order dated so and so. It's a covering letter, Sabine Yasmin and Imran Ali. Kindly turn the page 78. The repetition in nutshell. What is the cause of action that has been recorded? Second page, points of law involved observation of the Honorable High Court at Calcutta. Or contra observation in respect of the private respondent. Page 82, name of the applicant Imran Ali, Habana Ali, and marks. Total score based, kindly see. The most suitable candidate recommended for appointment got 78.66. And the person whose name may be recommended got 83.66. Three types of measurement in 3 section. I can show you a lot. Imran Ali was recommended by the district level fair by Shopkesh Chair.
Measurement, there are 3 measurements.
Yes.
In case of both the parties.
Absolutely. There are 3 inquiries. Kindly take note of. I shall 1 second show to your lordship.
7th November, there was an inquiry by the district magistrate, on behalf of the district magistrate.
Yes.
That is the last inquiry.
First point, pilot, whether there is any requirement of fresh measurement or not. Justice Chaudhary directed on consideration of the report submitted before him. Whereas the submission was that I have been favored with the inspecting personnel.
No, you have challenged the read petition before this court,
Yes.
before Justice Chaudhary,
Yes.
on the ground that on the alleged day of inspection, the private respondent had no go down. So on that basis, the order was passed.
Yes.
To re-inspect and submit a report.
This re-inspection, kindly consider. After providing 4 months to allow him to complete the construction, the observation of Justice Chaudhary has been nullified. The case made out in my first petition is that he had no go down as storage on the date of first inquiry.
Now, whether is there any observation on the earlier bench that the inspection has to be conducted within a short interval or like that?
There was no observation
such
that next
direction is
inquiry.
there.
Nothing.
No such direction is
No such direction.
or whether there is there any direction that which whether this go down of the private respondent was prepared after the date, particular date. Is there such direction?
First pilot page 61. The observation. Further inquiry 32 that has been recorded. My specific submission that November inquiry is not permissible. The court take note of inquiry conducted up to 30th July 2022. That has been recorded in the order. Page 2. Inner page 2. With the observation that no notice was given to further second inquiry is not.
No, it is the direction upon the district magistrate to cause an inquiry, either by representative or by district controller food and supply Baharampur, and to dispose of the representation submitted by the petitioner within 60 days.
Within 60 days.
From the date of communication of this order.
And it has ultimately been done. Kindly see the date of order. 1st September 2023. And final order has been passed. I have shown to your lordship. Despite my repeated request, 20th May 2024.
No, what is your submission after the direction of this bench? The private respondent has again constructed.
Absolutely. My first submission before the coordinate bench was the second inquiry only to favor the private respondent.
Okay.
That was my submission. Court has not taken any decision. Your lordship, I take note of. Court left the matter to the hands of the district magistrate. Direction, if necessary, an inquiry. But it does not say all other inquiry report will go. It does not say the first inquiry where my name has been recommended for appointment has no manner of application. My point is their representation was there. Kindly take note of. In my writ petition, I have categorically stated that you have constructed the go down after March, that is after first inquiry. Direction was that to consider my representation. For that, whether any inquiry is required or not will be decided by the district magistrate. To consider my representation, if necessary, conduct a fresh inquiry. Because direction was to consider and dispose of my representation. The court held since 2 representatives are pending before the district magistrate, will take a decision. Had I been there, I should not have asked the court to pass an order directly to the district magistrate, who is the chair, the committee. But I cannot say anything. Now, your lordship, kindly come to the order in question I have shown to your lordship. Page 82 is the final order.
Yes.
Immunity was recommended by the district level fair price shop selection committee on the basis of the inspection and as got the highest mark, but the case file was sent back online from district director district level for re-verification of the measurement of the shop compo down of the applicant. Accordingly, after re-verification conducted by district level software committee, again got the highest marks on transfer. After 35 inspection conducted by the team, and the findings are almost same as previous inspection, and so the marks obtained by the both the applicants remain unchanged. So the selection of immunity margin transfer. So it says whatever inquiry has been conducted first, that remains unchanged. I have shown before your lordship the report of that inspection. Does it in any manner says that Imran will get higher marks? And this is in my absence. He passed the order almost after 1 year from the date of passing order when there is a direction for 60 days. He has not allowed me only 1 day's time. On the date I discharged from hospital. Prior to that, I intimated the DM. Heaven will not call for adjournment of 2 days or 3 days. Total violation of principle of natural justice. If the first report considered and it says in the final order that no report, there is no change of the report. Lordship, allow me just place the report once again before Lordship. One column, just one column. And the date.
No, on 13th of March, you are not there at the time of hearing.
No, that's my intimation. Medical certificate.
So
I
without
was admitted in hospital.
without hearing you, the order has
Yes.
passed.
Violation of principle of natural justice. I came before this honorable court. My representation has been considered as per direction of the honorable court in my absence, despite my specific intimation. Once again, kindly take note of 3 dates. 21st September 2023, Justice Chaudhary disposed of the writ petition. With the direction upon the district magistrate. Why this disposal? Kindly come to my page 62.
Last line.
Be that as it may, when the petitioner submitted 2 representations. So my representation was directed to be considered in my presence. After giving opportunity to the petitioner and respond number 9. Last 2 lines of the page 62.
Yes, yes.
Now what happened? Notice has been issued to me after so many dates. Kindly come to my lord. The notice at page. Just I'm placing before lordship. Inquiry conducted next 7th November 2023. Then representation. Then kindly come to my lord page 73. Specific intimation with medical document. As I wrote it, fixed was hearing was fixed on 13th March. They have received left hand side bottom 12th March. What is the enclosure?
Let them produce the original showing the receipt. Because this is the forged document. Kindly take the next 12th April letter. But page 77. Your lordship will get the district magistrate office stamp at the bottom left hand side. 77. Kindly see. And kindly see this letter 73. It was never sent. The generated after the order of this is May order. They are filing it in November, in December. And after making out this.
No, 73 is the page. 73 is the letter.
Yeah, that did not. That
is on 12th of March. Received by 12th of March.
We are any stamp.
Yes, it was on stamp and the left side. Left side below.
Nay, there is no stamp, my lord. There is no stamp.
Stamp is not visible, I think. But
there is no stamp, my lord. The signature is also different. And you also will find the 12th April 77. Kindly see the stamp. '77. Kindly see page 77. Has you also got it? This is the
receiving section may have given the stamp like that. This is the government office receiving.
A district magistrate stamp. Malad, this is the office of the district magistrate.
I know. However, if they have informed that matter on 12th of March, the hearing should be
postponed.
Malad, they did not inform.
All right, my lord. I am not relying this document. Kindly come to page 77.
No, the matter has to be.
It should be
taken note from the state authority.
Yes, but you have to kindly take 77.
77.
Kindly see the date, 4th April 2024. 4th April.
4th April.
Yes. Order has not been passed. what I have stated. I was in hospital. Please arrange a further hearing. You have waited. When they have passed the order, 20th May, this is near about 1 year from the date of passing order by Justice Chaudhary. Mr. Bandyopadhyay cannot say they have received this letter 4th April 2024. Order has not been passed on that day. What is the hurry after 1 year?
It also doesn't tally with the first paragraph of the order of the district magistrate. First paragraph of the order of.
Very unfortunate, my lord. Let him allow me to make my submission. I may be false. There may be a inquiry. I will accept that.
Issue is that you read the page 79.
My lord.
First paragraph of the order. In compliance with the stolen order number such and such, hearing date was fixed on 13 March.
Yes.
Hearing notice bearing number such and such was served
Yes.
upon the petitioner as the private respondent
Yes.
and other concerned officers. That on 13th March the hearing was heard.
Heard. To the private respondent.
Whether anyone was present or they are not.
Private respondent was present. Admitted position. I was not present. They are not saying I was present.
It was not mentioned that
Yes.
the petitioner was present.
Yes.
It was also not mentioned that who were the present there.
Yes.
Yes. Proceed.
I shall.
Let us come back Monday. It's 4:30.
I shall take another 10 minutes now. On judgment, I shall be there. Or possibly Mr. Bandyopadhyay has concluded his submission.
I'll show what they did.
My client is.
I have chalked out a plan. I should inform the officers of the Food and Supply Department that they should inaugurate an office at the chamber of the junior of Mr. Sahara, and all applications for appointment of fair price shop dealer should come to them, and they will scrutinize and they will give appointment.
You know whether we have already opened.
They have taken the burden of selecting a dealer by themselves.
You know whether we have already opened or not.
No, you cannot open. Your junior master opened.
Very.
I shall show you first inspection 500 square foot super mile 100 client is. Second inspection 600 square foot. Third inspection 700 square foot.
He got the inquiry report. It's not available. Even under RTI, one can get. No RTI has been disclosed. He got the inquiry report. He got even the score sheet.
And submission before
and
the
that has been annexed.
And submission before the Chaudhary on behalf of the
I have seen.
And before Justice Chaudhary submission, learned advocate for the private.
Because he didn't read the next paragraph. He
admitted the inquiry was done and he got 59 marks.
But he didn't read the next paragraph.
So what is the purpose before the district magistrate again to rehear the matter?
Director.
Director
Yes.
should be
Yes.
proper authority to.
Violation of principle of natural justice. He is totally involved with the matter. District magistrate.
Now the district magistrate and IAS officer is also involved in the granting of fair price of dealership. Well, these wild allegations, it should not be encouraged by the court.
Whether I have been provided.
I'm taking a strong.
Whether I have been provided an opportunity.
Wild allegations against IAS officers, a senior. It cannot be. It should be. It should not be encouraged.
Oh, wow.
No, Mr. Bandyopadhyay, they are writing the orders like that, like the court, everything. They have just read about the orders. They read the orders, but they have not mentioned that the parties are present, who are present there. It should be very clear.
Have the copy of the attendance sheet.
Yes, attendance with the government officers.
Yes. I don't have any instructions to that effect.
Let them produce the report, file.
In May, the order was passed. They are coming in December after 7 months and asking now the court to decide even without filing the affidavit.
Absolutely.
Then court should be. There's no need. We should not make any submission. Let him record the order.
No, you have to submit.
Absolutely. Then only the Mr. Sahara can write the order.
After 1 year, no opportunity of hearing.
Let the matter appear in the list on 23rd.
अरे तो पकड़ लेगा तो अब क्या रहिएगा वहां पे?
Yeah.
After that, my lord will attend his function.
My lord, my lord, extremely sorry to disturb you again, my lord.
Just wait.
Fees দেবে আমার সেকেন্ড দিনে ফিস দিতে হবে ক্লায়েন্ট আমাকে টাকা দেবে না আমার যারা মামলা করছিল দেবে না শেষ হবে সে অলরেডি জিজ্ঞেস করেছে কি হায়ার আছে
রিকল আমি করিনি, আমি ম্যাটার অ্যারাইজ করছি কিনা দেখছি না। অর্ডার করতে বলেছি, আমি যদি ম্যাটারটা অ্যারাইজ করতো তাহলে অর্ডার করতাম। হ্যাঁ করে না, যা অর্ডার ছিল তাই করতো। হ্যাঁ ছাপবেন, মেনশন ম্যাটার রেখেছেন 23rd মেনশন ম্যাটার রেখেছি না, তাই তো। হ্যাঁ ছাপবেন, হ্যাঁ ওকে।
My lord,
নো
দেখে গেছেন